Yes, call the
Parvati to mention on motion.
not mentioned today.
On non-prosecution. Non-prosecution.
Motion
Come on Tuesday, come.
It was returnable today, man. It's not appear.
Huh?
It was returnable today, man. It's not appear, man.
Returnable today?
Yes.
For what?
Application, motion, man. Petition. Yes.
No, I know the mentioning day is Tuesday. That is why I'm praying for leave to file a writ petition. And so it appears on Tuesday. The urgency is that the two writ petitioners are two badminton players who have been suspended for 6 months without any notice, any inquiry, any report on an oral allegation, not even a written complaint. But the tournaments would start and my registrations would start. That is the urgency I shall serve.
When the tournament will start?
It's going to start in December and the registrations have already started. And the closing date is 20th in one for one tournament, 23rd for the other tournament. So if it could appear on Tuesday, my lord, because I am unable to practice also because of the suspension.
Have you not?
Very short. No, I have not filed. I'll file it today. But if it could appear on Tuesday, my lord,
You granted?
we shall serve. Great.
File and listed on Tuesday.
I'm great.
As new motion. Yes. Not mentioning today. Mentioning only the Tuesday and Thursday.
My lord, may I have the time to mention this matter? My lord, to move unlisted. My lord, electricity has been disconnected. My lord, this is a cafe, and every day, each and every day, the employees.
When it was disconnected? 4th of November.
My lord, I have already paid the electricity bill because in areas, but still they are asking for a security deposit of 2.5 lakhs. Unless the security deposit is being paid, the electricity will not be reconnected.
Why the security deposit? New connection?
No, my lord. My lord, there was a disconnection because of non-payment of.
Correct.
And thereafter, the electricity bill has been paid.
Correct.
But they are not reconnected because they are because of the security deposit. My lord, there has been deposit paid already before 3 years when this cafe was started. But now they are asking for more. My lord, 71,000 is already as a security deposit paid. My lord, now they are asking for 2.5 lakhs because there has been areas of 2.5 lakhs. My lord, the electricity bill has been paid, but they're not reconnected. My lord, if it is not reconnected, my lord, there is Saturday and Sunday, and each and every day he's suffering a huge loss, my lord.
Even today, I cannot take the matter today.
At 2 p.m., my lord, I file and come back, my lord.
How it is possible today?
Supplementary list, my lord, he's suffering a huge loss, my lord.
Are you in position to file and list, affirm the affidavit today itself?
Yes, my lord.
And notice?
My lord, it is ready. I can serve the notice in the meantime, my lord, kindly fix it at 2 p.m. of any time today, my lord, because there is a weekend, my lord. And a cafe runs at a profit on weekends, supposedly.
Liberty to file and listed in the supplementary at 2 p.m.
My lord,
If it is affirmed.
my lord, I know your lordship doesn't take original side mentioning now, but this is really, my lord, that suit where, my lord, your lordship had fixed it on Monday, Tuesday, and Wednesday, all days at 11:30 when your lordship was there. My specially assigned non-commercial. It's commercial. I heard what Mr. Rai was saying. My witness will come or not come on that basis. My lord, kindly looks at your lordship's order.
Give.
That suit where, my lord, that elderly gentleman used to come from Pune. Mr. Dhruva Ghosh was leading me.
That
Shuman Dutt,
bank.
yes, Shuman Dutt used to, my lord, that England bank in England, my lord, that those shares.
I don't.
So whether he will come or not come.
Specially assignment.
Yes, specially assignment. At least, my lord, even if any time, if your lordship indicates some, then accordingly he'll, my lord, also arrange his affairs because he came back. He will come only for
Do
this.
one thing.
Yes,
Come
my
at 2:30.
2:30.
Yeah, 3:30.
3:30. I don't know. I'm very afraid. I'll come at. May I come at 3 then?
Yes, you come at 3.
3.
Because my
Port officers. Yes. I'll come at 3, my lord.
Let's check the day.
Yes. I'll come at 3, my lord.
Manutosh ko bolo 3 baje. That today not the date for.
May I have lordship to mention, my lord, this is the matter for inclusion in.
Come on Tuesday. I will take the matter. Come on Tuesday. Mention on Tuesday. I fix the mentioning matter.
Lord, Justice, Honorable Justice Tirthankar Ghosh had released this matter.
Okay, no problem. I will take on Tuesday. Come on Tuesday. Yes, call the
Item number one.
My lord, I am appearing in this matter online, my lord, with your lordship's kind permission.
Yes.
My lord, this is a matter, my lord, where, my lord, the respondent West Bengal Mineral Development Corporation had invited bids for establishment of check post, my lord.
May
My
I
lord,
just
why?
interject in the meantime, Millard, because I think that judicial propriety would demand the matter to be released because challenging the same tender, one more writ petition was filed in Group 1 determination. Look, this is the order passed by the coordinate bench, Millard.
Whereby the
Because we were
coordinate bench refused to grant any interim order and directed the parties because in the meantime work order has already been issued.
Look, irrespective
My
of
lord,
what
this is a complete different issue, my lord. My lord,
Because
may I
there is
just
a-
point out, my lord, the matter, and then my friend may indicate it, my lord, what it is, my lord, because that
No, whether you file the analogous matter before the court number.
no,
other
my lord,
court.
I have not
Some other
filed
party
any
had
analogous
filed
matter, my
the
lord.
same
This is
tender process.
absolutely incorrect. This is
You
the
were
first
parties
matter
therein,
which I filed.
Ah.
This is the first, this is the only matter which I have filed, which is before your lordships, my lord. So, my lord, may I just place my case, my lord? My friend is saying interim order has been refused. So, may I just show, my lord, with your lordships, whether the same matter is there or not? Kindly come to annexure P6. He's saying about some other group. This is a
Same
complete
matter,
different
because I
matter.
can produce the writ petition also. Same matter, same tender.
Same tender.
I am the successful bidder, Millard.
Ah.
Work has been assigned to.
Ah.
I am the respondent number 4 here in Millard. In that writ petition,
My
I
lord,
was
kindly
respondent
see
number
the
9.
credentials of
No,
respondent number
when
4,
this
my
order
lord.
was passed, 26 September.
26 September.
26 September, that time there was a determination. Now the determination
Yes.
is this court.
No, Millard. At that point of time, 2 writ petitions were filed. One in Group 1 determination because this relates to mines and minerals.
Ah.
Another one in Group 9.
Ah.
Group 9 is the matter that is before your lordship now.
Ah.
The Group 1 matter which was filed by the other applicant who was also a bidder in the
Ah.
process.
Ah.
That writ petition is this writ petition in which the interim order was refused.
Correct.
But my humble prayer would be this writ petition will now come up before the bench having Group 1 determination.
No, my lord, this is a pure tender matter, my lord.
Complete. May I just complete? Group 1 determination has entertained the writ petition believing that this is maintainable under Group 1. Look, same subject matter cannot be maintainable in 2 groups.
So, my lord, may I just point out to your lordships, my lord, whether the group is correct or not?
What is the tender for?
Yes, the tender is for.
The tender inviting authority. The tender was invited for setting up checkpoint operator because these vehicles carrying of sand, there are requirement of checkpoint operator, whether they are carrying more sand than the required permissible limit. For that,
Well, let
purpose,
me-
tender was invited. The government of West Bengal, they have appointed authorized officer. These checkpoint operator were invited for to assist the authorized officer in collecting the revenue and intercepting the vehicles. They will logistic support they will provide to the assistant of the authorized officer. For that, the tender was invited. Therefore, Lordship kindly recall this matter was mentioned on third on the simple issue that because of the pendency of the petition, their EMD has been withheld. That is absolutely incorrect statement. I have
Sir, are you not allowing me to address the court at all?
asked them to provide bank accounts so that we could refund the earnest money. They said that no, since we have challenged our disqualification, we will not take refund of the money. So these are the documents on this limited point. Your Lordship was kind enough to fix the matter as to be mentioned. If your Lordship kindly recall that submission made on the 3rd of November.
My lord, may I just show the urgency in the matter, my lord, if your lordship permit me, my lord? They are saying about Group 1 and Group 2.
If the analogous matter is fixed before the other court, why this court can take? Let I am releasing it. Take
So there is
the
a chance of
assignment.
conflict of judicial decisions.
My lord, with all due respect, my lord, if your lordship, the recent judgment of the Honorable Supreme Court arising from Honorable Calcutta High Court itself, with respect to the allocation of group of the matter.
Correct.
Yes,
But,
my lord, the group of, but
the
this
court
matter
has
is a
also-
pure tender matter, my lord.
But the
It has
court
always,
has also to see in with regard to the other analogous matter is pending before the other court.
but
If the other court is
but that analogous matter is not a mines and minerals matter, my lord. That's what I want to point out to your lordship.
Yes,
Kindly come
where
to
is the
page
tender?
33.
Where is the tender?
Yes, tender is at page 22, P2, page 22. The other court, my lord, it would have not been pointed out that it's not a mines and mineral matter. Kindly see page 22. P2 is page 22. It is for selection of, may I just show to your lordship, expression of interest.
Where is that?
Page 22, my lord, P2, page 22.
Yes.
Yes, my lord, kindly see this is an expression of interest for selection of checkpoint operator for setting up and operating the checkpoints. It has nothing to do with mines and minerals. Now, what my friend says, kindly come to page 33 of this. well, this is the background of the tender, which is given introduction and background. My lord, I take your lordships to page 34. Kindly take, my lord, page 33, 4.1.3. My lord.
Yes.
The state government intends to promote sustainable and environmental mining in the state. Steps are taken to curb illegal mining and transportation, like introduction of central online portal, enforcement APP, vehicle location, tracking device EC. To further strengthen the enforcement measures, has decided to select and engage checkpoint operators possessing adequate technical, financial strength and experience in the field to check the quality and documents during transportation of minor minerals. So, my lord,
Correct.
it's a pure tender matter where
Your
only
tender matter connected with the miners and minerals. So how this court can do that?
Coordinate bench has entered in the
And already one court has already entered into the matter.
So, my lord, may I only request if your lordship are tagging it with that matter, a
The-
date may be given, because I can just show with respect to respondent
The
number 4.
petitioner has filed the present application in connection with the tender notice issued by the government of West Bengal for selection of checkpoint operator within bracket CPO for setting up and operating the checkpoints. Learned counsel for the private respondent as well as the state respondent submit that
And for the one and state is not a party and the
1 and 2 and
Right.
respondent number
My
1
lord, I
and
am
2 and the
updating for
private
respondent number 4,
respondent.
the private respondent.
Private respondent submits that the similar tender was challenged before the another court having determination of mines and minerals, as this tender is connected with the mines and minerals, and accordingly the honorable court has entered into the merit of the matter with respect of challenge of the said tender by another party, and the honorable court has refused to grant any interim order. Now the petitioner has filed split application before this court, as this court is not having the determination. Heard the learned counsel for the respective parties. This court find that clause 4.1.3 of the tender notice states that the state government intend to promote substantial and environmental friendly mining in the state. The steps are taken to curb illegal mining and transportation, like introduction of central online portal, enforcement APP, vehicle location tracking device system, etc. To further the strengthen the enforcement measures, WBMDTCL has decided to select and engage a checkpoint operator within bracket CPO possessing adequate technical, financial strength and experiences in the field to check the quantity and document during the transportation of minor and minerals. This court finds that this is connected with the mines and minerals. This tender is connected with the mines and minerals. Thus, this court is not having determination. Accordingly, the matter is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
We are just kindly record that you are ready and willing to refund. They are not taking refund of.
Why
No,
I
no,
am
no.
not entering into the merit?
Determination is good.
I am not entering into the merit. Why just? क्या हुआ? क्या करेक्शन है? कौन सा? क्या नंबर है? ओरिजिनल नंबर क्या है? वही तो है, देखिए 23479. हाँ, the Matter is listed as to be mentioned for correction in the order dated 3rd November 2025. It is found that in the cost item, the WPA number is recorded as 237.
I am appearing on behalf of the petitioner, my lord.
2025. So the correct number is WPA 23479. Accordingly, the order dated 3rd November 2025. The writ petition number shall be read as WPA 23479 of 2025 instead of 23749 of 2025.
My lord, item number 2, my lord, I am appearing on behalf of the petitioner.
Correction, that WPA number. WPA number was wrong. 749479. Yes, item number 3.
This matter has come under my instance.
Yes.
We were not served any notice of mentioning, my lord. My lord, this was appearing as item number 58 on 4th, my lord. We were not served any notice of mentioning. We do not know why the matter is appearing under the heading to be mentioned. I am appearing for the respondent number 9.
Yes.
Doctor, this is my affidavit of service of the notice also, that I have intimated that the matter was mentioned, and Lordship, the matter has been fixed on 7th, Lordship, the 11 November 2025 under the heading to be mentioned. This is my affidavit of service of notice.
After mentioning. After mentioning notice.
It is the practice of this court. If it anybody mention, I will not take the matter on the same day. The matter will be fixed for mentioning. Then notice is to
Even
be given.
over
The same
telephone,
thing
I
has been done.
requested my.
Have you received the notice of the man? After
We have received a notice
uh,
that the matter will be appearing as to be
on
mentioned.
that day, I have not passed any order.
Because the notice, the confusion was that the notice stated that the matter was mentioned on the 3rd. Now, on 4th, the item was appearing as item number 58.
And it was 58. They mentioned they wanted to upgrade the matter.
Very well.
The Lordship, this is my affidavit of service in respect of the writ petition.
Yes. Why? What is the urgency? You mentioned that.
Now, Lordship, urgency, Lordship, I am coming to the writ petition. Before that, Lordship, supplementary. No, ওইটাতে একটা আর একটা affidavit service হবে তো। আরে writ petition affidavit service। চেক কর।
Because I have a preliminary point regarding maintainability.
Lordship, the urgency is the Lordship, affidavit service of the writ petition is kept with the record because earlier occasion I now Lordship, Lordship, the urgency is this. Before going to the records, Lordship, the deed of the petition interest of this petitioner, this is a gift deed, has been cancelled, and Lordship directed to delete the name of the Lordship, the donee from the records of the ADSR registry office. Also directed the concerned inspector in charge to assist the concerned block development officer to Lordship, the handover, take the possession of the land of the premises in question. Now, Lordship, all these things have been directed within a certain period. Now, Lordship, this order was passed on 10th September 2025. I got the order on 15th September. I filed this writ petition on the opening, that is 27th. Now, Lordship, 27th I served. Now, Lordship, the last occasion, Lordship, this respondents has took time because due to taking the instruction, could not be heard. On the Monday, I mentioned this matter before your Lordship.
Yes.
Urgency, Lordship. Now, Lordship, kindly come. What is my case is? Lordship, the case is, Lordship,
You raised the point of maintainability.
Yes.
You are appearing.
So there is a provision for appeal.
Yes. Let the maintainability point be taken first.
regarding maintainability. Lordship.
Yes.
Just kindly have the statute.
ঠিক আছে আমি দেখে আমি also I have
Section 16 million. So it states that section 16 subsection 1, any senior citizen or parent, as the case may be, aggrieved by an order of the tribunal, may within 60 days from the date of the order prefer an appeal to the appellate tribunal. But now the provisos are there. Now, the only question for determination which is there, that it is a dispute or a list between the senior citizen and the other party, who can be a third party, who can be a relative, who can be a children. Now, the provision for appeal states that only a senior citizen can maintain an appeal. Now, the question might arise whether the other party against whom the list is filed by the senior citizen, whether he can maintain an appeal or not. Look, this proviso, the virus of this proviso was challenged in a writ petition before the Honorable High Court at Punjab and Haryana. Look, this is the judgment by a division bench headed by Justice Paul Millett, deciding the virus. Look, kindly just refer to certain paragraphs. Look, I'll just give the citation also. Look, this is reported in 2014 SCC Online, Punjab and Haryana 10864. Yes. Just kindly, it is not, paragraph numbers are not there in the judgment. Kindly have page 8, internal page 8 of the judgment. Yes. The right of appeal of an affected party other than a senior citizen or parent. The provision is quoted, Millard. Kindly thereafter comes to page 9 in the middle, Millard. Kindly sees their lordships therein also interpret section 15. An appeal is envisaged against an order of the tribunal. This is how section 15 reads. It does not say an appeal only by a senior citizen or parent. However, subsection 1 of section 16 refers to any senior citizen or a parent aggrieved by an order of the tribunal. This seeks to give an impression on a plain reading as if only a senior citizen or parent can prefer an appeal, and thus restricting the appeal to only one set of party while denying the right of appeal to the opposite party who are liable to maintain. However, this is not followed by the first proviso, which deals with the operation of the impugned order during the pendency of the appeal and clarifies that the pendency of the appeal will not come in any manner in the way of children or relative who is required to pay any amount in terms of any such order to continue to pay such amount. Now, it can hardly be envisaged that in an appeal filed by the senior citizen or parent, there could be a question of absence of stay. Such absence of stay was only envisaged where appeal is preferred by a children or relative. It is that eventuality the proviso deals with. The proviso is thus consistent with what has been set out in section 15 of the Act. Thereafter, Millard, kindly comes to page 10, Millard, last paragraph. An amicus was appointed. It has been submitted by the learned amicus that the subject matter of right to appeal is not merely confined to the issue of maintenance up to an amount of 10,000, but of seriously affecting the right of parties, even qua immovable properties as set out in section 23, the case at hand, because this deed has been cancelled. Thus, transfers of immovable properties can be declared void. This power is vested not only qua family members or children of senior citizen, but qua every person. Not only that, as stated aforesaid, the provisions of section 15 and 16 subsection 1 have to be read harmoniously. Section 15 nowhere mentions that the appeal against the order of the tribunal can be confined to a senior citizen or parent. Similar is the proposition qua the first proviso to subsection 1 of section 16, which would only have been in a case of an appeal by the party liable to be maintained. The right to file an appeal is not excluded specifically by the provisions of section 16 subsection 1 of the said Act, but it fails to omits to mention. We may also usefully refer to subsection 5 of section 16, which provides finality to the order of the tribunal. Such finality can only be achieved after hearing grievances of both the sides. If the appeal is confined to only one party, then the finality can only be qua the rights of the party which has preferred the appeal and cannot be envisaged qua the opposite party, which would have to take recourse to Article 227 of the Constitution of India. Thus, another subsection, same section, gives credence to plea that section 16 of subsection 1 of the said Act should be read in a manner as to provide for appeal for both parties. This is the submission of the amicus, Millard. Thereafter, kindly just give me one moment, because it is not page numbered. Kindly directly comes to page 20 of the judgment. Last paragraph at page 20, Millard. Now coming to the conspectus of the discussion aforesaid, we have no doubt in our mind that we would be faced with serious consequences of quashing such a provision. So the question of IRES, quashing such a provision which deserves the right, which deprives the right of one party to appeal remedy, while conferring it on the other, especially in the context of the other provisions of the same section, as well as of the said Act. We have to avoid this. The only way to avoid it is to press into service both the principles of purposive interpretation and casus omissus. The parliamentary discussion on the other provision of the said act do not convey any intent by which there is any intent of the parliament to create such a differentiation. There is no point in repeating what we have said, but suffice to say that if nothing else, at least to give a meaning to the first proviso of section 16 subsection 1 of the said act, the only interpretation can be the right of appeal is conferred on both the parties. Now, my lord, thereafter it is interpreted and stated that by rules of purposive interpretation and casus omniscius, section 16 includes the right of appeal to all the parties. Now, my lord, just one more submission. Ultimately, a virus was challenged before a court having jurisdiction. My lord, kindly considers a situation if the provision was declared to be ultra virus, then it would have been ultra virus across the country
as a whole.
now, if while considering the virus, if a court decides, because the question is whether this is binding on this court or not. Now, while deciding a virus, if the court decides no, it is intra-virus, but giving a purposive interpretation gives an interpretation. In my humble submission, my lord, that will also be binding upon this court, because the question was whether the virus is ultra or intra.
Yes.
So there is my respectful submission so far as maintainability is concerned.
Yes, sir.
Kindly come, Lordship, the section 16. Any senior citizen or a parent at the case may be aggrieved by an order of the tribunal may within the 60 days from the date of order prefer an appeal to the appellate of tribunal. Now, Lordship, provided that on appeal, the children relative who is required to pay the amount in terms of the maintenance order shall continue in paying such amount, the amounts ordered in the manner directed at the appellate tribunal. Provided that further the appellate tribunal may entertain the appeal after the expiry of the said period. Lordship, this is a provision of, that's a condonation of delay. On receipt of the appeal, the appellate tribunal shall cause a notice to be served upon the respondent. Now, the appellate tribunal may call for the records of the proceeding from the tribunal against whose order the appeal is preferred. The appellate tribunal may, after examining the appeal and the orders called for, either allow or reject the appeal. The appellate tribunal shall adjudicate and decide the appeal against the order of tribunal, and the order of appellate tribunal shall be filed, and no appeal shall be rejected unless the opportunity of being heard to the parties. The appellate tribunal shall make an endeavor to pronounce its order in writing along with the one receipt of the appeal. The copy of the every order made under subsection 5 shall be sent to both the parties free of cost. Now, Lordship, kindly come to the rules. There is a provisions of adjudicating the appeal. That is the rule 9 of, this is the rules of framed by the government of West Bengal Maintenance of Senior Citizen Rules 2008. Kindly come to the rule 9.
Yes.
Composition of the appellate tribunal and the appeal. An appeal under subsection 1 of the Act along with the impugned order of the tribunal shall be filed before the appellate tribunal in Form C. Lordship, got it? C. Lordship, kindly come Form C.
Yes.
This is the prescribed form. And it appears from the Form C of the, Lordship, the rules framed by the state of West Bengal, that this format has been prepared for the purpose of the senior citizen. Kindly come Form C. Notice of maintenance of proceeding.
How this Form C will be applicable?
Kindly Form C, that is the notice. Kindly Form D. This is the form for appeal of the appellate tribunal.
Correct, it's appeal.
Yes, that is Rule 10.
Declare this.
Yes, name of the applicant, respondent, such and such verification.
Correct.
Lordship, the Form C, this is the notice, and Form D, it appears that this appeal is only maintainable in respect of the senior citizen.
No, actually, it should not be a Form C, it should be a Form D.
Form D.
Form D.
This is Form D.
If you see the Form D, see Sub-Rule 1 of Rule 10. So, Sub-Rule 1 of Rule 10 is the appeal.
Appeal. Yes, Lordship, this is a wrong mistake. This is Form D. Registration of the appeal. Upon receipt of appeal, the appellate tribunals are registered if the register is maintained for such presupposes.
That is the procedure.
That
So
is the
what you want
procedure.
to say? What about your reply to the judgment, which the respondent is relying
Now,
upon?
Lordship, the first of all things, Lordship, kindly come to the order. Now, kindly come to this, my writ petition at a glance, Lordship, the merits. Lordship, this application under section 4 and 5 proceeding has been initiated. Now,
Who are you?
Lordship, I am the persons, my Lordship, the initially respondent number 9, Lordship executed a gift deed in favor of the predecessor in interest of the present petitioners in the year 2014. Now, in the gift deed, Lordship, there is no, Lordship, the admitted, Lordship, there is a, Lordship, the condition that the donee, Lordship, donee, there is a relation like a son. Donee is not a relative of the Lordship donor. Now, donee was looking after the donor like a son. Lord's being satisfaction of the donee's service, the donor executed a gift deed in favor of the predecessor interest of the petitioners and the donor's sister.
That's correct. That is on merit of.
Now, Lord, I am coming to the violation of natural justice also.
You tell me, have you gone through the judgment?
No, Lord,
So
admittedly, I have not gone.
you go through the judgment, you give the reply on that, then I will, if the court will satisfy, yes, it is maintainable, then we'll go enter into the merit, otherwise I will pass. You go through the judgment.
Now, apart from this,
Yes.
Lordship, if it is a judgment is
Right.
there,
Ah.
if it is judgment is there, I have made out a case that this is absolutely violation of natural justice and without jurisdiction.
Where is the order?
Lordship, kindly, before coming to the, kindly consider the proceeding which have been supplied to me after filing of the writ petition. Kindly come to the proceeding. I have supplied the copy.
First, so show the, where is the order, impugn order?
Impugn order of last page. The proceeding has been initiated against the dead person. My first condition is this, submission. Lordship, kindly come my application under section 4, read with section 5 of the 2007 Act. Supplementary. Lordship, kindly come to the application.
What application? I am asking you to first to come to the impugn order. Where is the impugn order?
Here are page 113. This only order has been passed. Seen the inquiry report submitted by the Sushanta Kumar Maiti, such and such, it reveals from the report that the petitioner Sipra Mukherjee, widow the late Subrata Mukherjee, 73 years old lady, residing at a house at Kamarpatti Para, such and such. Now, under Rampurat police station, Birbhum, 35 years ago, her husband was died on a road accident along with the only daughter. Since then, she has been passing through a lonely, helpless life, and recently he has been suffering from various ailments due to her old age. The petitioner does not have any source of income except the house from where she earns some money as the rent of the tenants. 2 shops keeps in ground floor and 1 tenant on the first floor. Since after death of the husband of the daughter, she started to impart some private tuition in her house, and her tuition was a student. Devasis Dotto, son of late Sarod Dotto, who is the predecessor in interest of the petitioner of Rampurat, Kalisarapara, came to take part. Since then, the Devasis Dotto had been starting to take place with love and affection like a son in the heart of the petitioner, Srimati Sipra Mukherjee. The Devasis Dotto engaged himself in all types of rendering services like marketing, purchase, medicine, company, in doctor's visit, etc., and earned faith and trust of the petitioner with a great obedience and sincerity. Dated 19 September 2014, the petitioner Srimati Sipra Mukherjee executed a gift deed in the office of the ADSR Rampurat in the favor of 2 donees like Sudipta Maulik and Devasis Dotto, the lordship such and such, including 300 square feet portion of the house in ground floor and 200 square feet portion of the house in the first floor of the donee number 1 and 0.03 acre of the land of the same plot to the donee number 2, including 350 square feet portion of the house in the ground floor, 250 square feet portion of the house in the first floor. Thereafter, by executing a declaration through the supplementary registered deed, such and such, Ramphura dated such and such. She corrected land Siddle given by the donee number 2 from such account to such acres. Donee number 1, Sudipta Maulik, is the own sister of the donor, Shipra Mukherjee, but the donee number 2, Devasis Dotto, was declared in the deed gift to be like son of the donor. It is not understandable how the gift deed was allowed to executed in favor of Devasis Dotto, with whom there was no blood relationship with the donor. Now, Lordship, this was the contention, Lordship, that as it is no blood relation, the gift deed cannot be executed. However, the aforesaid gift deed was executed in favor of both donees on condition the rest of the life of the donor and donees will be looking after the providing all sorts of livelihood and maintenance of the donor without any kind of negligence and lack of care. Dated 7th October 2020, the donee number 2, Devasis Dotto, passed away. But the petitioner Shipra Mukherjee even don't know the news of the death of Devasis Dotto, as she said. She stated that before execution of the gift deed, Devasis Dotto looked after her with utmost care and affection. But since after execution of the gift deed, slowly, Mr. Dotto started to keep himself away from the petitioner's caring and rendering services. Even the own sister of the petitioner, Sudipta Maulik, donee number 1, didn't take care of her sister and has not been providing any maintenance of the petitioner. Now, as a result, nowadays, the state of the petitioner has become as follows. She has become helpless, shelterless, and having no house, such and such, that after the death of Devasis Dotto, his brothers has been extending their rodent grass and grabs the house of the petitioner. Anytime the petitioner 73 years old lady may be driven away from the house, as the entire house has been grifted under undue influence, the petitioner doesn't have any other source of income except the earning from the rented portion of the house. Hence, recommended that this is a high time to take the necessary steps under section 23(1) of the Maintenance and Welfare of the Parents and the Senior Citizen Act 2007 to protect the interest of the petitioner and maintenance and welfare of the senior citizen like the petitioner Srimati Shipra Mukherjee. Hearing of all concern, considering the inquiry report, it appears that the gift deed being such and such, dated such and such, registered ADSR Rampurat, were executed on faith subject to condition that donee shall provide basic amenities and basic physical needs of the donor, but the donees have refused to provide such amenities and physical needs, so that the transfer of property is being deemed to the tribunal to have been made by fraud and coercion or undue influence and deserve to be cancelled. Hence, ordered that as per section 23(1) of the Maintenance and Welfare of the Parents of Senior Citizen Act, the tribunal do hereby declare the deed such and such of the office of the ADSR be void and cancelled. ADSR Rampurat shall note that above order for the cancellation of 2 deeds of the margin of the copy of the book as Rule 17(4) and 17(5) the West Bengal Registration Rules 1962. Also on the online portal, Ankur Mitra, WBCS Executive of the Block Development Officer, Rampurat 1 Development Block, will recover the physical possession of the house stated.
What happened to the sister?
Nothing.
She's also not looking after me. Her deed also has been cancelled.
She has not challenged that
But
deed.
No.
Now, but Lordship, this her property, only kindly last portion, only these petitioners have been directed to remove from the property.
Deed is cancelled, means all consequences.
7. Kindly come paragraph 7. Ashish Dotto and Subhasis Dotto, who are the brothers of the deceased, both son of late Sarod Dotto residing such and such, has been directed to be removed.
Yes.
Now, Lordship, kindly come. What was the initial application? Kindly come initial application. Page 5 of my supplementary affidavit.
Yes.
That was
Have
certified
you saw the
copy.
copy?
I have.
Yes, I have received a copy.
Lordship, kindly come. This is an application for cancellation of gift deed. Lordship, who filed this application? Respondent 9, Shipra Mukherjee. And Lordship, against Sudipta Maulik and Devasis Dotto, who expired in 2020. Now, Lordship, what is the reason of this application? Kindly come. Paragraph 3.
What is the prayer?
Prayer is the cancellation of deed, but Lordship, what is the grounds of the prayer? The deed has not been acted upon. The gift deed has not been acted upon, has not been accepted. Kindly come, paragraph 3. After such sad demise, her daughter and the husband was emotionally shocked and shattered. Thereafter, on advice of some well-wishers, your petitioner engaged herself in a constructive activity like teaching. Your petitioner started imparting private tuition to some poor students like her locality. It is stated that the petitioner, while imparting private tuition, one boy, namely Devasis, joined petitioner's private tuition. During that period, petitioner was really impressed of the new boy Devasis, sincerely and obedience. The said boy was treated like a family member by the petitioner and reciprocity of this boy used to do all the household activities of the petitioner, such as marketing, purchase, medicine, and to accompany the petitioner to the doctor of her treatment. That since death, the daughter and husband of the petitioner became helpless, lonely. Now, Lordship, kindly come that the details of the gift deed executed, kindly come paragraph 6. Details of the gift deed executed by the petitioner as gift deed number 1 such and such. Subsequently, another gift deed such and such. It is reiterated that both Devasis Datta and Sudipta Maulik did not accept the gift deed executed by the petitioner. This was the pleadings before the learned tribunal that they have not accepted the gift deed. Now, said Devasis Datta such and such never made any attempt to accept the property of the petitioner which was executed earlier by the petitioner in the favor of the donee. Devasis Datta has not come to the house of the petitioner since long time, does not make any inquiries about the petitioner, does not take care of the petitioner, does not extend any help in the manner whatsoever. Devasis Datta, Lordship, already expired in 2020 during COVID-19. Said Sudipta Maulik, daughter of such and such, has been rendering service to the school teacher at Alipurduar. Due to her job, she cannot reside regularly with her sister. She frequently comes to the house of the petitioner to enjoy the property, but does not take care of the petitioner. Petitioner is helpless and has been passing the days of helpless condition. That the opposite parties by their conduct neglected the petitioner here by depriving the petitioners assured care. It is appropriate opposite to state herein that the opposite parties never accepted gift deed for which the gift deed is void ab initio.
What is the condition in the gift deed?
Now, Lordship, kindly come the gift deed. The gift deed,
32 minutes.
page 32.
Writ petition.
32 of the
Writ petition.
petition.
Writ
Yes.
petition.
32 of the writ petition. Now, Lordship, this so far the sister's part is concerned, she already transferred by way of sale.
In Bangla language?
Yes, will.
Now, Lordship, I am reading this. Lordship, this is আমার দৃঢ় বিশ্বাস জন্মাইছে যে আমার শেষ জীবন পর্যন্ত ওই রূপে সহযোগিতা করিতে কোনরূপ অবহেলা করিবে না. This is the language. Lordship, it is presumed that the donee from the beginning how he was given services to the donor, it will continue on future. This is the language has been written. Now, donee is expired in 2020. Now, Lordship, this is the two part of the gift deed, cedil. Kindly come that cedil of the gift deed, two part. Lordship, kindly come to the cedil two part. That is one, kindly come page 35. Lordship, I will translate, Lordship. No.
You have mentioned the matter, you could have been come with the translated copy. Page 35.
Page 35.
Yes.
Cedil ko and cedil kho.
Correct.
Lordship, I will. But what the purpose of the Lordship? Because I am in
You
the.
might interpret, but the court has to go.
Yes.
No. I will, Lordship, translate those. Obviously, deed I will translate. But Lordship, I only, Lordship, today I am praying before your Lordship because the order in such a manner, because this order
What is the position of the property now?
property is in my possession.
Ah,
Now let's say police has been directed to remove us from this lawful possession.
hmm.
Now let's say for the time being, because let's say this is a two-sidle. One is the sister, one is the
Have you received the notice before passing the order, whether the concerned authority have given an opportunity?
now
to
let's say
you?
this is the issue. The case has been started against the dead person.
Correct.
Now let's see the inquiry, let's say 22nd, the
There is the inquiry report.
kindly come to the inquiry. 22nd directed to conduct an inquiry, 23rd inquiry report submitted
Inquiry.
on the next day,
Where is the inquiry report?
and the same line of the judgment. And no notice of the inquiry, no.
I am asking, where is the inquiry report?
Lordship, I'm coming to the inquiry report.
Page 10 of the supplementary.
Yes, kindly come page 10. Lordship, kindly come the order of passing inquiry, that is 22nd September, 23rd inquiry completed, submitted within a night.
Where?
Okay, page 10.
Yes.
Report regarding the petition of Srimati Sipra Mukherjee under Maintenance Act, order dated 22nd September 2025. Now, Lordship, kindly come page 12. Twenty-third inquiry report completed and submitted also before the sub-divisional officer by 12 noon.
How the inquiry was conducted? From whom into the inquiry?
Nothing else. We have no knowledge of the inquiry report. The inquiry report, everything has been done in the.
Whether the inquiry report was submitted to you,
No,
served to you before passing the order?
no, nothing. Lordship, I have got it.
Have you received the notice of the proceedings?
Yes, Lordship, I
Yes.
coming to the order. Lordship, I am coming to the order. Lordship, the proceeding was initiated on 12th September 2025.
Hmm.
Lordship, we are not the parties. As per the rules, there is a provision of amendment of the cross title
Have
addition.
you received the notice?
Lordship, kindly come page 13.
Page
13.
13 years.
This order passed ex parte. First day of the order admitted.
Correct.
22nd September, direction of inquiry. No notice has been served.
Correct.
23rd, report submitted with the rider that Devasis Dotto, who is a party to the proceeding, expired.
Yes.
And Lordship, kindly last line,
Issue notice.
23rd. Hence, issue notice to the encroachers to appear before the city. Lordship, we have been identified as the encroachers.
Correct. Where is
Now, Lordship, kindly come the notice. On 23rd, the notice has been given. Kindly come to the writ petition.
where is the notice?
Page 111. Lordship, notice has been issued to the two of the petitioners. Petitioner number 1 has not been issued notice. Though petitioner number 1 is the having title in the property after the demise of Devasis Dotto.
Ashish Datto and Subhasis Datto. Yes.
But petitioner number 1 has not been.
Have you received the notice?
This notice has been served.
You had appeared before the authority?
Authority on 25th September I appeared.
Yes.
Now, Lordship, kindly come the next page. I produce those documents that a civil suit is pending, Lordship, in respect of the parties, where the donor is a party in the civil suit. Because this is a partition suit, we are unable to access our, Lordship, the property, Lordship, according to the gift deed. Now, this is the P51112, the civil suit is pending. In the civil suit, we have disclosed the Devasis Dotto expired. Notice has been served to the donor, that is the applicant. Yes, I will annex the order. Now, in spite of the said notice, the application has been filed against the dead person. Now, Lordship, 9th October, the order has been passed. Without giving any chance to filing any objection, no perusing the reports.
Where is the further proceeding after the issuance of
That
the
is
notice?
page 112, 100, Lordship, the next page.
11.
This is the 9th October order has been passed.
9th October.
That is the impugn order.
Impugn order.
That is the impugn order.
But by an order dated 23rd, directed to issue notice, 25th September. What has happened on 25th September?
25th September, Lordship, no order has been passed. That is the entire certified copy I have collected from the department.
Yes. Yes.
Now, Lordship, this is the one thing. Lordship, I am just coming. This is the one thing of the aspect. This is absolutely violation of natural justice. It appears from the notice that petitioner.
Okay, now what further you want?
Lordship, the proceeding under section 4 and 5. This is the proceeding under section 4 and 5 cannot be initiated against the who is not a relative.
Yes, who is
No, Lordship, not a relative. I have a judgment of this thing. Kindly come. Not a relative cannot do.
This is the proceeding under 23. The
No.
judgment can-
Kindly come. This is the proceeding under 4 and 5. Lordship, it appears from the heading of the order.
Have I asked for maintenance?
Lordship, kindly come to the impugn order. This is a proceeding under section 24. We read with section 5.
Where you find? Yes.
Lordship, kindly come.
Proceeding
the
under
notice?
section 5, read with section 6 of the.
Yes. Now, Lordship, if it is a proceeding under section 4, read with section 6, it has to be initiated against the relative within the meaning of section 2G. Lordship, kindly come to the definition of section 2G. Relative, what is the definition of relative? Relative means any legal heir of the childless senior citizen who is not a minor and in a possession of or would inherit his property after his death. So, Lordship, if the donor expired and the property inherited to the person, he will be relative.
Yes.
Now, Lordship, kindly come section 4 and 5. Because notice has been served under section 4 and 5 that the proceeding has been initiated. Any senior citizen, including parent, who is unable to maintain himself from his own earning or out of the property owned by him, shall be deemed to be make an application under section 5 of this act. The parent or grandparent against one or more children or being minor, childless senior citizen against other his relative referred in clause G of section 2. So, Lordship, this application has to be maintained against the relative in terms of section 4 and 5. Now, Lordship, kindly, this is the division bench of the judgment of Ernakulam, the Honorable Division Bench judgment that a proceeding under the Lordship, the 4 and 5 cannot be maintainable against a person who is not a relative. Also, this is unreported, so I'm supplying a copy, Lordship. Lordship, kindly come. Lordship, the paragraph
9.
Paragraph 9, Lordship, initially paragraph, Lordship, the 4, page 3. The section entitles a parent to seek maintenance under section 5 against his children, and if a person is not a childless senior citizen against a relative, defined under section 2G of the Act. The liability to maintain a senior citizen is a relative of a senior citizen. To attract the section, he must be a relative of a senior citizen. He must sufficient means to maintain the senior citizen. He must be in possession of the property of the senior citizen. He would inherit the property. Now, Lordship, kindly come. Paragraph 7. The first condition is to satisfy that must be a person in a class group legal heirs of the senior citizen. A legal heir is a person who under personal law is entitled to inherit the estate of the deceased. The classes of persons who are legal heirs are also specified in the personal law of the parties. So the first condition is that the person must be legal heir of the senior citizen under the personal law. The other condition are of the such legal heir must be in possession of the property of the senior citizen or would entitle the property. It is only the satisfaction of our condition that a person would be a relative of a senior
Yes.
citizen.
Another, what is the judgment?
Now, Lordship, another judgment, Lordship, this is the division bench judgment also, that against this, except relative, no case is maintainable, Lordship, under the sections 5 and section 6. Kindly comes, Lordship, the paragraph 5, 4, 5, 6, and 8.
Yes.
Hey, Supreme Court judgment.
Unreported.
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 Yes.
Yes, any further?
Now, Lordship, this is the Honorable Supreme Court judgment that procedure has to be followed. Lordship, the procedure, that is in terms of the notice. Now, Lordship, there is a provisions of, Lordship, the evidence also. Unless the procedure is follows, Lordship, now, Lordship, I'm relying upon the Honorable Supreme Court judgment. That is, yes. 2000, Lordship, 22 SCC online, SC 1684. Lordship, kindly come paragraph 11. 11, 13, 14, 15, 16, and 17.
Citation double बदल रहा है.
Citation is 2022 SCC online, SC 1684. Lordship, kindly 15, 16, and 17th also.
Good. Yes.
Now, Lordship, this is the judgment of this Honorable High Court. Now, Lordship, because directly, Lordship, in all these judgment, Lordship, against the cancellation order of the gift deed, Lordship, directly Lordship, file this application before the civil division, and the civil division also has been entertained. Now, Lordship, directly to before the Honorable High Court. This is the Honorable High Court's order.
Whether the Punjab and Haryana High Court judgment was dealt with there or not will be relevant.
That is correct.
Because otherwise then it will be a case of sub-silence.
Lordship, kindly come paragraph 7. That was the order, and Lordship, the paragraph 8 and 9.
That is the order recorded.
Yes. Lordship, kindly come paragraph 11, 12, and 13 and 40. Sanipara division.
Aro debe? Add you na, please.
But kindly see the paragraph 14. In the present case, admittedly, there is no such express condition in the deed.
So here is also, Lordship, the condition, even, Lordship, for the sake of argument, there is a condition. Condition upon the Dhoni. Dhoni expired, Lordship, 2020. And Lordship, kindly come before Lordship closure. I'm just praying for Lordship attention to the suit which has been pending.
Now the question here, if the Dhoni died and the gift deed is
That is the main question.
So what would be the effect of the gift deed?
Now, Dhoni is died, Lordship. In terms of the provisions of law, these petitioners have a right title interest of the property. Lordship, this issue will dealt with by the London Civil Court. That is, issue is pending. Lordship, kindly come 84, page 84 of the writ petition. Lordship, how these things have been suppressed by this Lordship, the applicant before this tribunal. All these things have been suppressed. Page 84.
Yes.
Now, Lordship, the defendant number 1, Sipra Mukherjee is a party. Lordship, got it?
Yes.
Kindly come.
What is
Paragraph
this?
7.
Suit for partition.
No, yes, paragraph 7. Paragraph 7, it has been pleaded that Devashish Datta expired on 7th October 2020. Now, Lordship, kindly come to the orders. Page 91. Defendants filed their learned advocates Hajira. Page 91. So, defendant Lordship be aware of the fact that Devashish Datta expired long back ago. Now, Lordship, apart from these things has been suppressed. Lordship, curious thing is, Lordship, this is a total 7 decimal of land.
Okay. Yes. What is the
So
content?
firstly, my lord, the entire argument, my lord, may I? The entire argument that section 4 and 5 only is maintainable against a relative is fallacious. Kindly have page 5, which is my
Leave aside that. I am not going into that. If a application is filed, if you are based upon the report, whether you are not a author, you are not duty bound to serve the copy of the report to
It has
the
been
cons-
served.
Where is the show me the record?
Kindly have. Look, the
Show me the record whether the report was served upon the authority and the respondents.
May I just indicate this? Lord, kindly give me 2 minutes. 2 minutes. Firstly, I file a case against the Tony, knowing that he is alive. I am not aware that he has expired. My lord, because he did not turn up, the tribunal, in its wisdom, appointed somebody to conduct a field inquiry. Now, kindly sees the bogey that is being played by the petitioner number 1 hearing. The person who has been entrusted with the inquiry goes to the spot, finds only petitioner number 2 and 3 there.
Correct, no problem.
So kindly appreciates.
Yes.
The person, the Tony who has died childless. He does not have a child, did not marry.
Correct.
Nobody in ordinary course of business or knowledge is supposed to know how many brothers or sisters he will have.
What the inquiry officer will do?
May I just, I am coming.
Why the inquiry officer has been appointed by the authority?
Just give me 15 more seconds. When he goes there, he speaks to these 2 people, the petitioner number 2 and 3. They do not disclose the name of petitioner number 1.
Where is your officer says where the record says that this petition did not disputed anything?
Kindly,
Where that order says, or you have given an opportunity for the.
I am a 75-year-old lady.
You leave aside the 75. I am on the procedure. I am the procedure. Court cannot, yes, you are the 75, whatever the procedure the authority can do. Authority has to go by the law prescribed.
Certainly.
Then
I am not disputing that. Milord, only the petitioner number 2 and 3.
I am setting aside, remanding the matter back to conduct a fresh inquiry and dealt with the matter and pass appropriate order. Yes.
But since it has not been solved, what we can do, we can solve the.
Yes, you submit inquiry report.
Taken up from the state.
Correct, no problem.
Report is there, he's not disputing that. When from the inquiry found out that the Dhoni number expired.
That's why I'm telling. Report is there from the stage of serving the report to the petitioners and the. I am not setting aside the inquiry report. I am not setting aside the inquiry report because he has not challenged the inquiry report.
But now he has it. Now he has it.
Yes, he has it from the. I am giving the liberty to file a.
Response to it and the proceeding will be taken up from that.
May I just indicate one thing, Lord, in that event? Kindly protect me by an interim order because the inquiry report says that they are in possession of only 2 shops.
No.
Status quo as on date.
No.
But kindly appreciate.
You go and file.
But
before
tomorrow,
the-
if I am removed from there, my lord,
No, how you will be removed, sir?
if they remove me,
What the occupation of their premises, whatever it
because
may be.
because I am also in that premises.
Maybe.
That is what I am asking.
Okay, I am passing at the status quo to maintain as on date.
Yes.
Yes.
Till the disposal.
Yes, I am also agree.
Give them certain time to respond to it. In the meantime, they will maintain status quo.
Yes, maintain status quo.
Keep the border from my head also.
Correct. Maintain status quo till the disposal and the authority will dispose of. How much time? How much time it will take?
You can file it within 14 days. We adjudicate within one day.
So I am fixing for 6 weeks. Time is granted.
For that, 14 for us.
Now, Lordship, kindly give me liberty to file a detailed, Lordship, the objection as well
Detail,
as.
whatever it is, I am giving a liberty to give response to the report within 2 weeks from date.
As well as my application. As well as application. Yes, my learned friend.
As well as the application, if any response is received by the authority will dispose of the matter within 4 weeks after receipt.
Very well.
And
Extremely-
till the disposal of the matter by the concerned authority, both the parties are directed to maintain a status as on date with respect of the nature, character, and possession of the property. The
এই
petitioner
আমাকে ওই
has
জাজমেন্ট একটু দিন তো, আমার ইয়ে হয়ে গেছে
petitioner
একটাই
has
কথা।
filed
না না আমি দিয়ে দিচ্ছি,
present the
আমি জাস্ট লিখে দিই। না
challenging
একটা একটা ওইটা
the order
ওইটা হ্যাঁ just
passed by
এটা হ্যাঁ ওটা থাক।
এটা লিখে নাও একটাই copy।
the presiding officer, maintenance tribunal, Rampur Hat subdivision, and subdivisional officer, Rampur Hat, dated 9th January, 9th October 2025, wherein the learned tribunal, learned presiding officer, has asked order by declaring the deeds by numbers 08121 slash 2014 dated 19 September 2014 and wide number 00255 slash 2014 dated 14/11/2014 of the office of the ADS Rampur Hat be wide and cancelled and consequential orders have been passed. The first contention raised by the petitioner in the present application is that the concerned authority has initiated the case on the complaint of the private respondent under section 5 read with section 6 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007. And he submitted that the petitioners herein against whom the impugn order is passed are not the relatives of the private respondent, and thus the proceeding initiated by the presiding officer is valid. The second contention raised by the petitioner that the proceeding was initiated against a dead person. But after the inquiry officer came to know that two of the persons, namely Ashish Datto and Subhasis Datto, are in possession of the property in question, and a notice was issued, but no hearing was conducted, and the report has not been served upon the petitioners so as to enable the petitioners to respond to the said report. It is the further contention of the petitioner that there are three brothers of the deceased Dhoni, namely Devasis Datto. No. Devasis, what is the name of the Dhoni? Or his name? Devasis Datto. But only two persons have been issued notice, and the third person has not been issued notice. And he was not aware of the proceeding initiated by the concerned authority. The learned counsel for the petition further submit that the presiding officer has passed the order further submit that the order passed by the presiding officer dated 9th October 2025 is the replica of the inquiry report, and he has not given any opportunity of hearing to the petitioners. These are the four.
Petition number 1 has not been given.
That are already
I'll also only one thing like that. They are not the relative of that.
that also recorded. The counsel for the private respondents raised the question of maintainability of the present date application and submits that as per section 9 and section 16, there is a provision of appeal, but the petitioners, instead of filing an appeal against the impugn order, has filed the present date application, and that thus the writ petition is not maintainable. The private respondent has relied upon the under the relied upon the judgment in the case of Paramjit Kumar Soraya versus Union of India and others, reported in 2014 SCC Online P&H 10864, and submit that in the said case, the similar point, and in the said case, the Honorable Division Bench of the Punjab and Haryana High Court has held that even if the is not a senior citizen or not a relative can maintain the appeal under section 16 of the said act. Learned counsel for the private respondent further submits that after the inquiry officer came to know that after the death of Devasis Datto, the two persons are in occupation of the premises in question, and accordingly their notices have been issued to the said two persons. With regard to the third persons, nobody has disclosed the identity of the third person, and as such, the no notice has been issued to him. That I will record. He further submit that though the in the co-title of the order, the concerned authority has initiated the proceeding under section 5 read with section 6 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007, but the application filed by the private respondent before the concerned authority, there is a specific prayer for declaring the deed of gift, which covered under section 23 of the Act. When a counsel appearing for the estate submit that the on receipt of the complaint from the private respondent, inquiry was conducted, and upon inquiry it was found that though the deed was executed with the condition that the donors will look after the old age person who is the private respondent herein, but subsequently the donors failed to look after the senior citizen, and accordingly the authority has found that the complaint made by the private respondent is correct and passed the impugned order and does not require any interference. Had the learned counsel for the respective parties peruse the materials on it. This court finds that the private respondent has made a complaint to the concerned authority, to the sub-divisional officer Rampur Hat in the month of September 2025. Immediately on the receipt of the complaint, a report has been called up by the sub-divisional officer. On receipt of the report, it was found that the one of the donee, namely Devasis Datta, died, and two persons are in occupation of the premises in question, and accordingly the sub-divisional officer has issued the notice by fixing the date on 25th of September 2025. On 25th of September 2025. But this court find that on 24th September 2025, no proceeding was held. But finally, the sub-divisional officer has passed the impugned order. This court finds that sub-divisional officer has relied upon the inquiry report on the basis of which the impugned order is passed. This court, without full stop, pass. This court is of the view, it is the specific plea raised by the petitioners that no opportunity was given to the petitioners, and the petitioner and not getting petitioner, so that the petitioners would deal with the report on the basis of which the impugned order is passed. Considering the above, this court finds that the petitioners, while passing the impugned order, the authority have violated the principle of natural justice by not supplying the copy of the report to the petitioners, and the petitioner could have not get an opportunity to deal with the report on the basis of which the impeachment order is passed. As regard the question raised by the petitioner that the proceeding is initiated under section 4 and 5 of the Act, but the officer has passed the order for declaring the deed as void. This court find that though in the cause title it has been recorded that the proceeding under section 5 and 6 of the Maintenance of Welfare of Parents and Senior Citizen Act 2007, but in the application filed by the private respondent, a specific prayer is made by declaring the deed as void. Full stop. Taking into consideration, would find that the submission made by the petition does not stand. The authority has to go by the complaint filed by the complainant, and the complainant and the authority has considered the complaint filed by the petitioner, filed by the private respondent, and passed the impugnment. This court has not gone into further detail of the matter. Full stop. This court find that the petitioners could not get an opportunity of hearing, and has also not get an could not get an opportunity of hearing to deal with the report on the basis of which the order is passed. Accordingly, the order is set aside. Order dated 9th October 2025 is set aside and remanded the matter back to the respondent number to the respondent number 7. To the respondent number 7. To consider the case afresh. Consider the case afresh after giving an opportunity of hearing to all the parties, to all the affected parties. As the petitioners have got the copy of the report, the petitioners are directed to file the exception, if any, within 2 weeks from date before the sub-divisional officer. If the sub-divisional file a exception to the report within 2 weeks from date, and also at liberty to file their objection, if any, to the application of the private respondent before the sub-divisional officer. If the sub-divisional officer received any exception to the report as well as objection to the complaint filed by the private respondent, the sub-divisional officer shall consider, and after giving an opportunity of hearing to all the concerned parties, to pass a reason and speaking order within a period of 4 weeks thereafter. 4 weeks thereafter. Till the disposal of the matter by the sub-divisional officer, the parties to the present proceedings are directed to maintain a status quo with regard to the nature, character, and possession. It is found that the sub-divisional officer has received the report that the original donee Devasis Datta has died, but instead of impleading the legal heirs of the Devasis Datta, the sub-divisional officer has proceeded the matter. Accordingly, the petitioners of the present writ applications are directed to inform the sub-divisional officer with regard to the legal heirs of Devasis Datta, and if any information is received by the sub-divisional officer within 2 weeks from date, the sub-divisional officer shall implead the legal heirs of Devasis Datta in the complete petition and will pass appropriate order as directed above. Yes, that I already only gone. He have not gone into further merit of the matter. That come, then we'll see to that. That's why you're not decided.
So far the inferior is concerned with was concerned.
Yes, set aside with the above observation, the impugnment order dated 9th October 2025 is set aside. Oh, yeah, na? It is. Thank you.
This the 4 I beg to appear on behalf of the petitioner. So, my lord, my case is before your lordship is that the admitted bill amount which has been withheld by the authority concerned. So now kindly come to page 9. Pursuant to the work order, malad onwards, the documents is there. Pursuant to the work, malad the supply order.
Just a minute. 6 payment of the bill of midnight. The learned counsel for the state director to revert with the report. Where is the report?
Malad this the malad before placing the report, I have gone through the report. I have
Let the court may also go through the report.
malad I have malad this report has to become with an affidavit, and because of that, they are disputing the signature which has been put in my bill by the erstwhile video. That's why I am placing my case before your lordships. Then your lordship, kindly, I have prepared a supplementary this the affidavit. Some money has already been paid. Some portion they are denying. That the this kindly go before going to that the report. Place my case.
Yes. Tell your case. No. I will hear
Kindly
your
come to page 9.
page 9.
9 in my writ petition.
Yes.
So now this is the work order.
Huh?
Work order, a supply order which has been issued by the erstwhile video,
Chicken, water bottle, tea, biscuit, and tiffin.
etc. Now next, page 10.
Have you supplied?
The-
And raise bill.
Kindly see the signature, that is AAC, bottom AAC. This is the own, that means
AHC.
AAC.
Correct.
That means account head clerk.
Account head clerk.
That has been written by the erstwhile video.
Okay.
না আমার এই পরেরটা দেখুন 10 পেজে। Then my lord, then my lord top certified that the head clerk certified that I have supplied the goods. Got my lordship. This bill appears from the report denied. Only on the ground there is no official seal is there. Now my lord, this is a very vital. The signature of or recommendation of the erstwhile video AAC. That is very vital. Now, next, my lord, page 11.
ASC, what you say? Accounts head
Account
clerk.
head clerk. Now, then, my lord, page 11.
Yes.
Page 11, another supply, my lord, this supply order which has been issued by the erstwhile video. See the, my lord, the signature also, the video, erstwhile video. The page
Same.
11.
These are the same.
Same.
Yes.
Up to my lord, this is the similar issue. My lord, this the now I am coming very vital issue.
Without the tender, all the order has been given
No,
to you.
because of this is not required because of the supply of
Okay,
the
whatever it
program.
is. Yes.
Now, my lord, this is kindly last bill, page 18, kindly see.
Page 38.
Page 18.
8.
18. 18.
18.
18.
Yes.
My lord, this is the same. Then, page 19. I raised the bill. My lord, AIC, my lord, got 19.
Yes.
Now, this is the official. This is no work order. This bill has page 19 has come. Page considering the page 20. No, my lord, is a very vital. The date of my lord is so many materials and food has been supplied to the video in different programs, all maintained by the video office. That is their video office records. Now the signature 18th May 2022. My lord, got the point. My lord, this is the bottom. The signature of the erstwhile video. Page 20, my lord.
Page 20.
Not, sorry.
Page 20, yes. Kindly come to the serial number 179.
179.
Yes. Got it?
Got, I got.
Got it.
10,000.
What is the date of that?
My lord, this is your lordship, kindly come to.
In that, serial number 179, 19, serial number, bill number 19, dated.
That is not my claim here. I am not claiming on that. My lord, part payment has been made out of those the item which were supplied by the authority concerned.
Okay.
Now, my lord, this the signature is the same.
Okay. Next.
My lord, this the now again page 21. Page 21.
Again order.
Supply order. Now page 22, the AAC got my lord the bottom, the erstwhile video, stamp.
Okay,
Official
whatever it is
stamp
now,
is-
now what is the case now?
My submission before you are twofold submission. First submission is this: once you have given a part payment accepted by the erstwhile video, rest of the portion cannot be denied. That is the settled law by the Amjad Hossain judgment by my Lord Justice Anuruddha Rai. I will place before your lordships. Now, third, my lord, it is my lord, it is my, though my lord is a lordships, no, a video, my lord, is the block development officer. Pursuant to his work order, I have done the, I have supplied all the materials. Now, one thing is this, that is very, another vital point, page 37.
37.
37.
Yes.
So now it is admittedly, my lords, there is no work order. He direct me, my lord, is verbally to repair my quarter, to supply the furniture, to supply the inverter, everything I have supplied, that is admitted by the erstwhile video.
So what contractor you are? You are caterer or you are the?
Well, both. Both. I have been enlisted both. Now, part payment has been made. Now they have come with the report. Kindly come to my supplementary affidavits. Only I segregate because of that part payment has been made, which is not required to annex the supplementary. My lord, I in place it.
Yes, next.
Now, my lord, is the kindly come to the note sheet which has been annexed in their report. Signature is the page 7. My lord, is the date AAC, that is the video which has been, my lord, relied in their report. That payment has been made based on that signature AAC. There is no dispute. Now, second, my lord, the page 18.
Page 18.
8.
Yes.
My lord, the bottom AAC. They
Page
have
18.
made the payment.
Page 18.
1-8. My lord, sorry, my lord, 8. Next page. 8. Only 8.
Yes.
8. Got my?
Yes.
So, my lord, this official seal is there. But this is the AAC, this is the own handwriting of the erstwhile video. Because of that, I have referred the matter, my lord, is the note sheet of the video. Now, 9 page. That is my claim. AAC. Everything I have supplied. Rest, next, my lord, page 10. Part payment has been made.
The same document which you are relied upon.
Because of that, those are denied on the grounds I have made in this party. Only grounds, there is no official seal.
Okay.
There is no work order. So now I have come before your lordship twofold submissions. Once the chair, that means erstwhile video, made the part payment, the subsequent chair cannot be denied. Rest portion has to be paid. My lord, this is the one judgment I may refer. Amjad person. So my lord, this is the Arakadam. Answer, don't go. Me and my lord. Lots. My lord, this is my lord. I have to quote. I will supply to my learned senior friend. So my lord, one judge. My lord, this the my lord Justice Anuruddha Rai. Recently, my lord, this was held in the September 3rd. My lord, this may I read? The petitioner stated that arising a tender work order was issued on such and such in favor of the petitioner carrying out the certain civil work construction. The entire work has been completed by the petitioner to the satisfaction of the concerned respondent, municipal as would be evident for the work order certificate and to the petitioner on last date and such and such. No objection or demur was raised against the work done by the petitioner by the concerned municipal. The petitioner has raised a bill, running bill, a part payment has been raised. Part payment has been made to the petitioner in pro tanto satisfaction of the claim of the petitioner as would be evident on the page number Sajan, the petitioner claim balance amount. So now, next, my lord, is the kindly come to paragraphs 4 and 5. 5 is the very, when a part payment you have made, pursuant to the, my lord, this the document or record maintained by the authority concerned. So you cannot deny the balance payment that has been held by this honorable court.
Here is the tender issue.
This is because of the tender. Work order is the part of the tender.
No, that's why they have taken the plea. Where is the work order issued to you?
So now, no, my lord, this is absolute correct. No work order is there.
Correct.
My lordship,
Only supply
so
order.
now the chair, being a BDO, he made the part payment. Made the payment because of the supply 4 bottles water. So now this is not the tender is required to supply for biryani, 4 packet biryani. This is a cyanic cataract. I supply this. This is not required. They have maintained the official record. They have paid 1,000 something. Then in total 1,43,000. Now the construction or repairing of my house.
Okay. Yes, madam.
Second subsection. Second judgment is this. This is the Supreme Court. He has come with a report without an affidavit. Let them to come with a complete affidavit. I have not done the work. I have not supplied the work. Then I will take, because of all the irrelevant document of the erstwhile video is available. Let them to come with a complete affidavit by way of affidavit. That has already been held by your lordship in 4th of my lord this month. I moved this application. There was also direction to come with an affidavit. So let them to come, then I will, if they specifically denied, I will take.
Yes, what is the contention, sir? Page 2 of your report. Writ petition. Writ petition.
Page 2, paragraph
Yes.
that your petitioner states that pursuant to the work order of the executive officer of Lord Development Officer 1 block, district South Chobis Pargana for supply of kit and other things, my lord. Your petitioner completed the work successfully and supply the material.
Correct.
Work order is there. He can't deny that. I can't keep that work order. It is needless to mention here that completion of the work of the supply of the materials the raise the fee of our payment of admitted amount. However, the fees were accepted other. Certainly, most of the fees have already accepted the certificate by the recipient of the fee. Now, my lord, what I am my lord asking first page. Duplicate and repeated claims. These are claims which have already been paid by the company, but have been intentionally included again in the writ petition is repeated claims. Certain old claims already paid once by the office have been deliberately repeated in the writ petition by the petitioner with the applicant intending the proceed. That is my lord first page. Now my lord second page.
Yes.
Now second page, my lord. False and non-genuine claims. The time frame of the false claim of the following works made by the petitioner is found in the nature, tenure of the then block development officer with work block. There is no such critical existence or viability in the said work are verified. These claims do not have any work order. This is very good. Nor is there any critical existence or viability of the alleged work. Hence, there is no question for payment of false, non-genuine and purposefully made claims by the petitioner. A list of unpaid malad that I am mentioning here. That is page 2. My lord, if paragraph 2, my lord, your lordship believe it, that all the work was done by the as per work order. Then, my lord.
So then I will specific direct you. I will pass an order.
Yes,
File an affidavit specifically what the admitted claim which you have paid. Show the work order.
Yes, sir.
Disclose the work order. On the basis of work order, you have.
Now, this is page 2. That claim, my lord, that is when you work order.
Correct.
Now, my lord, claims. These following bills claims were not actually received by the office. My lord, আমরা কোনো পাইনি, যদি যায় আমার কোনো আপত্তি নেই।
সব দিয়েছে
Moreover, no such
শীত নেই
দাঁড়াও বাবা। No such official listening stamp or no such marks of receiving along with the docket number with date are found in the copies of the following bills which are annexed in the petition of by the petitioner. Now it is to state that these bills are not found in the present official records and no such physical entity or physical violation has been done by this following. Mother, if you can.
Okay, you file affidavit disclosing all.
my lord, this is the only pair.
You file affidavit.
my lord,
No, it is by way of affidavit so that he can get an opportunity to file a
Yes.
reply.
my lord, only one submission before your lordship, my lord.
The-
My lord, only one submission before your
In
lordship.
terms of the order passed by this court, dated 15 September 2025, the authorities have submitted the report disclosing certain documents and denying the claim of the petitioner. This court finds that though the authorities have denied the claim of the petitioner, accordingly the petitioner should get an opportunity with regard to the said denial. In view of the above, the respondent authorities are directed to file
Block development officer.
the affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter. 2 weeks, 1 week, no? List the matter on 3rd December 2025 under the
My lord, the only one
My
pair.
lord, please.
My lord, only one pair.
And because my lord, now the SIR is coming, my lord, and all the
Huh.
videos are very busy for that.
My lord,
So my lord, some kind you will.
Okay, 3 weeks, 1 week.
my lord, only one pair.
Yes.
I
3 weeks,
have
1
been-
week.
Specifically submitted,
10th December.
my lord, specifically submitted that I have to make the particular.
Okay, you disclose.
My lord, no. Addition
Yes,
of
call the
party, I
next
pay
matter.
for addition of party of the astrology video. My lord, otherwise I will not get my lord, the genuine bill.
Where is your application for addition?
My lord, this I have made.
Where is your application?
Well, prayed for because of that they are not come with the my lord, the
Call
statement.
the matter.
My lord, this my lord, the 5, my lord, this there was a direction 5 to 13 is the same. My lord, this is the order which has been passed in the same video. There is a direction to file a report with an affidavit. My lord, this kindly see that.
What?
My lord, that order which has been passed by my lord Justice Amrita Sinha
Ah.
to disclose by way of an affidavit.
By way of let's go director blood to file report by way of affidavit. Today, when the matter is called, into the justice time to compare. Yes, where is the report? Affidavit.
Affidavit.
By way of affidavit.
Yes, sir.
When the SIR started. When the SIR started, sir. Huh? Last week, when the order was passed.
September.
19 September.
Our money is withheld since 2021.
The counsel for the respondents prays for extension of time to file affidavit in opposition as directed by this court dated 4th November 2025. Let affidavit be filed within 3 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 10th under the same heading.
Well, up to 13 is the same.
Up to 13. 5 to 13. Next.
Well, this is the same order which has been passed by the against the same video.
Yes.
Well, the same heading. Matter will appear in the same date.
Yes, next.
9th date.
Item number 6.
13 over, 14 call 14. 5 to 13 is over.
5 to 13, item number 11. But item number 11, I am appearing for the state respondent. Miller, here there is my lord, section 11. Here, Miller, the video has submitted the report, archival video.
Same report,
In
copy
the
paste.
meantime,
You file a report.
he transferred from the same.
Okay, you file affidavit.
My lord,
File affidavit, 3 weeks, 1 week. Come on, 10th.
give some more time.
Come on, 10th, we'll see to that. Yes. Next.
Up to 30. My learned senior.
Yes, call the 14.
They told to Lord.
I am appearing item number 13. Also, I am appearing for some time to file my.
3 weeks, 3 weeks.
3 weeks. 2021 সাল থেকে টাকা কোনো item number 1.
নিচে তো 11 নম্বর 11
14 কি আছে 14
Yes, so it's for the item number 14.
14 কি আছে Malad, my name is appear Malad, I have miss the whether I am the petitioner or not Pankaj Hallar.
Which matter?
No, sorry,
Item number 14.
sorry, my mixed. না আমার ভুল হয়ে যেতে পারে
Commit some judgments.
As, no, on the last occasion, as per the prayer of the petitioner, case adjourned. The matter was listed. The matter was listed on 3rd November 2025. But on the prayer made by the counsel for the petition, the case was adjourned till today. Today, when the matter is called, none appears on the petitioner, no accommodation is sought for. Accordingly, WPA 22663 of 2025 dismissed for default. Next.
The lordship, I'm appearing for the petitioner lordship.
Yes. Disconnection.
Not a new connection, your lordship. As well,
Courts will take steps for disconnecting the electric connection.
lordship also for new connection. Your lordship, the matter is this: that your lordship, the petitioner's father had got this property by way of a venture of lease deed. So, your lordship, after the father passed away in 2018, the petitioner and the private respondent became the legal as co-owner of the said property.
But this is only for new connection, Malab. I am the one of the owner in respect to this property. I have applied for the connection. Lordship will kindly takes.
No, kindly come to the paragraph prayer 1.
Yes.
Prayer A.
Yes, Malab.
Commanding the respondent distribution company take disconnecting the electric connection.
No.
Standing in the name of the deceased father.
Yes. I just want already there is a meter
So there
in
is
name
no
of
provision for changing of the name of the
yes.
there is no
My
provision in the law.
yes. What I'm on is that today I am in the first floor and my brother is not allowing it's a sub meter. So I just want a fresh meter to be installed so that I pay my bill because my brother there is a dispute between me and my brother.
So where is the main switch?
Lordship will kindly cease, I have stated that paragraph. Paragraph 9, if your lordship see.
9 of your petition.
I'm on my petition, yes.
9 of your petition.
Yes, madam.
Yes.
Your petitioner states that after purchasing the said property, the late father of the petitioner had got an electric meter installed in his name exclusively for the ground floor. On the ground floor of the said property having consumer number so and so, installation number so and so, and that subsequently when the first floor was constructed, the late father of the petitioner decided to apply for a sub-meter as he wished to let out a portion of ground floor to his tenants. But since he had already a meter in his name, the sub-meter was installed in the name of private respondent, herein exclusively for the first floor and garage of the said property having consumer number so and so. Now, dispute is here. But now, we two brothers are the legal heirs of the entire the property. Paragraph 11.
Who is for the authority? What instruction you are having?
As per my instruction, there are two existing meter connections and one in disconnected meter is there. Another question was there. One is in the name of his father, Rajendra Banerjee, and the another is, my lord, in the name of Uday Bhanu Banerjee.
Yes.
Who is he? Father.
Uday Bhanu is a private respondent.
Private respondent, his brother.
Brother.
Yes.
Yes.
But that is the submitter.
Yes. Then.
My lord, in the, my lord, in the meter connection, or in the name of Uday Bhanu, my lord, there is outstanding amount in SPSC 649. And, my lord, another connection has been found there. My lord, that is in the name of, my lord, the Pranab Kumar De, that is deemed disconnected. My lord, outstanding amount is 1397.
39?
1397. My lord, 1397.
1397.
1397. My lord, here, my lord, there is a, my lord, the authority has, my lord, after inspection, it has been found that there are, since, my lord, there are several connections. My lord, it appears, my lord, it is apprehended that this attempt, my lord, to get a new connection in the same premises, my lord, is due to, my lord, with the motive of, my lord, splitting of load. My lord, splitting of load, my lord,
No, no.
my lord, if, my lord, there is a tariff.
So he's not having the electric connection at present. The premises.
No, I don't have.
My lord, there is existing connection that has been disconnected.
See my
The
prayer, what
petitioner,
I've
where the petitioner, because it was in the name of the father. Father died.
Yes.
No, my lord, what happened as per his petition, my lord, the first floor and the garage, there is a connection.
That is a brother.
Name of his name of his brother, that is the private respondent.
Yes, brother.
Now the private respondent is not paying the rent.
Now, what has happened to the meter provided in the name of the father?
Father, my lord,
which he wanted to disconnect.
That is, my lord, that is life.
But I don't.
Respect to the ground floor.
Malab, may I clarify the situation?
The ground floor, the brother is already having his own name.
Yes.
To meter.
No. In the meter connection, my lord, in the name of his brother, that is in respect of the first floor flat, first floor of the building, and my lord, the garage. Now, my lord, after partition or my lord, the distribution of the property, my lord, he has got, my lord, the first floor portion. But the meter connection is in the name of the private.
That is the problem.
That is the problem.
My brother is not paying the bills.
If he's not having the electric connection, he has to give the electric connection.
Now, the authority, as per my instruction, it is apprehended that this has been done or this is being attempted for splitting of.
No.
That's why,
why splitting of load? How can
splitting
you?
of load will
No,
there is a slab or the tariff is determined.
Correct.
If it is distributed and it
So,
goes to the
lower than the charges will be less.
Yes.
Charges will be less.
So many meters are there. Another meter was there in the name of Sri Pranab Kumar De.
He was a tenant. He left.
That has been being disconnected.
May I pray before your lordship, today there is a dispute between the two brothers.
So in that case, what is your contention? So I am directing you to file a report. If now what is the load? What is the load? And what would be the meter charges they are paying?
Yes.
And if the new connection, what will the lowest charges will be there?
Now, may I clarify the situation of what my learned friend has said? There is
meter standing in the name of the private respondent that is still alive.
Private respondent is a sub-meter. Its connection is given from my father's meter.
There is no concept of sub-meter now.
I don't know what has happened. May I clarify the situation? Today, my brother is enjoying the ground floor. He is enjoying the electricity connection which has been installed in the name of my late father. I have been given or I have been residing in the first floor. Today, they are not paying the bills. Now, I want a separate meter. He cannot say the separate of load. Each and every. How can they be prejudiced? It's my. I want a new connection.
My lord, I am for the private respondent. I am for the elder brother, my lord. I have been compelled to move out from that residential property, my lord, and kindly grant leave to file wakalatnama in the course of the day, and kindly grant to.
How you will be affected if the connection is given to the brother? How you will be affected? There is no problem. You appear, you file wakalatnama. There is no
Yes,
problem.
and my lord, kindly grant
the new connection.
My lord,
If you say no problem, you will supply the electric connection from your
My lord,
meter,
the,
and both will share the meter charges. There will be no problem.
My lord,
If you
the important documents have not been submitted. Kindly grant leave to file the AO, my lord.
Well, only he wants to stall the process.
For opposition, my lord.
For what?
To submit the important documents.
That's it. See, here only the two questions. The authority which they raise, only their contention is that the petition intend to a new connection only for the splitting of the load,
Yes,
so that the meter charges could come less, which is liar. Now he is telling that there is no connection because you are enjoying the connection, so he wants
I'm not in.
connection. So if a meter connection, there are two options I am giving to you. Either he may be allowed to take a new connection, or you say no, there is already a meter connection, he is not required, and you are supplying, you are not disturbing, there will be nothing.
Now, my lord, that will again create difficulty. I have to come each and every time before your lordship. Well, only one thing. Well, I am asking, only I am asking a question to myself, my lord. Can an authority, my lord, run a meter in the name of a deceased person, a dead person?
So that is enjoying with that brother.
Well, I am, my lord, no. But today, my lord, what has happened?
Okay, I am. Please submit the report. How many meters are there? How many?
No, my lord, can in that case,
whose name the meter status?
What are the
and my lord, only
the meters
my
are
lord, lordship will
distributed
kindly
and whether
record.
the petitioner is enjoying any.
just a moment.
My lord, lordship will kindly record.
Difficult.
My lordship will kindly record, my lord. As per his submission is concerned, the elder brother is enjoying the father's meter
Correct,
and also in his name.
I am calling for the report.
Yes.
Difficulty is, my lord, he is seeking new connection in respect of the first floor of the building. Now, in the first floor, there is already an existing meter, though in the, yes, I will file. Well, difficulty is, my lord, since there is an existing meter and that
Who is using that?
my lord,
Who is using
that
that?
is who he has been using.
No, I am not using it.
He has been using. My lord, this is his own averment in the petition. He is staying there. He is in occupation of the first floor property, and my lord, he has been using.
He is taking
Now,
a stand which is beyond the law. But today, yes, you are taking a stand beyond the law.
The petition
Today, I am at sufferance. Disconnection was given.
Praying for electric connection in the first floor of the building where the petitioner is residing. The Learned Counsel appearing for the authority submits that.
মোড়া লোকের নামে আপনারা কানেকশন চালাবেন
ইন্টিমেট করো
Submits on
authority জেনে বসে
instruction
থাকবে না
that
গিয়ে
there
বসে নেবে কি?
আপনাদের তো অ্যাপ্লিকেশন করে দিলে যেমন সেখানে সব দিয়েছি তো
how many meters are there? There are
my lord, as per my instruction, already two live my lord, meter connection is there, and one is another connection is there was there that is deemed disconnect. I will disclose.
There are three electric connections and three existing electric connections already in the said premises. Police. He further contend that the petitioner intend for a new connection only for splitting of the load. Police. The counsel for the private respondent pressed for time to file affidavit by disclosing certain documents. Consider the submission made by the counsel for the parties. This full stop. The counsel appearing for the WBD, who is which company?
Well, WBSCDCL.
WBSCDCL is directed to file report by way of an affidavit by disclosing how many meter connections are in premises, who are enjoying the said meter connection, and whether there is any meter connection, there is any existing connection, and there is any electric connection in the premises of the petitioner. Let the said report be filed within 2 weeks. 2 weeks. After serving the copy to the Learned Counsel for the petitioner, release the matter on 26 November.
20, instead of 26th,
and in the meantime, I should have get an interim order,
subject to your lordship's convenience, can it be on 30th? 26, I have some difficulty.
28?
Oh, sorry. 28, perhaps it's, oh, sorry, October.
November.
28.
28 November.
But in the meantime, my lord, if I am enjoying an electricity connection through my brother's, because my lord, he is going to pay the bill, and that maybe my lord, bill maybe.
Come, report come. That's why I am passing any order. Let the report come whether you are enjoying the same meter connection.
No, I am not enjoying. Because after mutation, my lord, only I am enjoying the first one.
Okay, let the report come. Yes, next.
Great.
Yes.
I am for the petitioner, my lord. This is the second time before your lordship. On last occasion, my lord,
Though my lord, learned advocate for the distribution company appeared before your lordships, but the private respondent did not appear. But today, my lord, their status report says on 29th of October, the private respondent was served.
Why you not filed the affidavit?
My lord, affidavit is there on last occasion.
Affidavit is
Yes,
there.
yes. At that time, yeah, it was not available. Server was the.
So it is served.
Yes, yes.
Delivered on
all
29th October.
29th October.
Yes. Then who is
So,
for
my
the
lord, kindly,
authority?
this is for my lord new connection, my lord.
Who is appearing for the
Yes, I have deposited, my lord. Kindly have a look. Last annexure, my lord. On 20th September 2024, a sum of rupees 1,20,000, 3,98,000.
Page.
Page, my lord. Last page, annexure P5. Last one. This is the receipt, money receipt. Against my lord.
How much amount you have paid?
My lord.
How much amount you have
Yes,
paid?
1,20,000, 3,98,000, 398. Just
1,20,398. Yes.
So, my thereafter, my lord, when my lord distribution company, main and agent, my lord, went to effect my lord, install my lord electric meter, then my lord, the private respondent, who my lord resisted. Private respondent have no right because I am the developer. There is a joint venture agreement. I have annexed it. So, under no stretch of imagination, they can raise any objection. Now I completed the flat. Now the flat has been booked. Within a stipulated time, I have to, my lord, hand it over to the prospective buyers. And without electricity, it is not possible. If I fail to, my lord, install the electricity, the electric meter, in that event, my lord,
in whose name?
My lord, in my name, my lord, in my name, I am the developer. My lord, kindly see name Devashish বিশ্বাস, developer of Orange Nest. CSC না এটা
WB
হ্যাঁ কি দাঁড়িয়েছিল নামটা
WBSCDC
বেঙ্গলি ছেলে দাঁড়িয়েছিল হ্যাঁ হ্যাঁ দাঁড়িয়েছিল আবার একজন মানব ঠিক মালার ডিগ্রি থার্ড ডে 1 day before Justice Chandra, 1 day before your lordship, my lord.
But other authority has to
Simple
be,
matter on new
authority has to be represented. Give the copy. I am fixing tomorrow.
No, somebody has already appeared. I will inform.
Who is appearing?
Order আছে order
ওর নামটা নেওয়া হয়েছে
order হয়নি
ও সেদিন প্রাইভেট রেসপন্ডেন্টের কমিউনিকেশন এটা ছিল না ট্র্যাক রেকর্ডটা ছিল না
Well, I will talk to the authority, my lord. I will.
When?
Well, today.
Today
I will.
Password.
No. Kindly do not make it password, my lord. I will inform it, my lord. Somebody will appear on the next day, my lord. I will secure it.
On Monday top.
As per the accommodation paid for by the respondent, case is adjourned. Let the matter appear on 11th Tuesday.
Please not top.
Topi আসবে 79 for WBSDC.
My lord, I am actually tenant, my lord, your lordship. I have all.
I am instructed to appear in private respondent. No copy has been served.
সে কি কথা
My lord, the copy have well advance has been served, my lord. It will be appearing from the affidavit of service.
No, private respondent.
Yes. It has been served. My lord, the first contention is that the particular statutory authority have not refused to receive the.
Where is the track report does not provide that it is delivered. Can you come to the page 10 of your affidavit of service? Booked on 28. Where is the delivery?
Lord,
no delivery report.
This is actually, my lord, made.
Where's the copy?
At present, my lord, I have only one single copy.
You in course of the day get it Xerox. I am fixing on 11th.
My lord, I am just giving him. Before that, my lord,
He has to take instruction.
11th.
Brother, এটা একটু দেবে তোমার
কপিটা
my lord, before, my lord, this can be disposed of, my lord, today.
Yes, but opportunity, let he take instruction. I can dispose of, but tomorrow you will be in trouble if in the appellate court. Only one. I am not doing only the same day copy served, the court has passed an order. Set aside. The counsel for the petition has served the copy of the writ application along with the document to the learned counsel appearing to the private respondent. Counsel for the private respondent prays for time to take instruction. Let the matter appear on 11th. Yes.
The fixing on 11. Great. Copyটা copyটা দিতে হলো মামলাটা করার আগে।
Appear for the state, Malad.
Malad, I am for the petitioner. This is the affidavit of service, Malad. There are two private respondents. Six has refused to accept, and seven, the endorsement shows that he has left the premises. So this is the affidavit of service with the return date to envelope.
What you have prayed for?
Malad,
What you have prayed for? What is the prayer?
that is under challenge before your lordship is the order passed by the maintenance tribunal. That is the last annexure. If your lordship kindly come, if your lordship kindly come to page 71, that is the last page of my.
But kindly come to the writ petition, the prayer portion. Where is the challenge? Where is the prayer for setting aside the order?
Prayer B, your lordship kindly sees.
Prayer is the Nasai.
There is the authority to take appropriate.
Where is the Nasai? Is the Nasai? Where is the order for challenging?
Prayer B, my lord. B.
Prayer D.
B for Bombay.
B for Bombay.
Yes.
Restraining the private restaurant for conspiracy of grabbing the shop. Where is the challenge the order?
My lord, appropriate steps to protect the right to peaceful enjoyment of life of the petitioner by restraining the private respondent from the conspiracy of grabbing the shop room of the petitioner, which is the only source of income. Now, my lord, why? Because the genesis is in the process of conversion. The entire family has been converted to Christianity. Now, my lord, your lordship kindly sees there is a civil suit, and the private respondent number 6 preferred that civil suit, and he has failed to offer.
Who are you?
I am the daughter-in-law.
You are the daughter-in-law.
My lord, I have been on several occasions along with my two daughters have been pressurized by the my lord, matrimonial house in-laws, my lord, to be converted to Christianity. I stood firm and I denied. That is the whole genesis of this episode, my lord. And during pendency of this, my lord, one DV Act proceeding and another, my lord, maintenance proceeding under 144 are pending before the learned court below. And my lord, before the learned maintenance tribunal, your lordship kindly once, page 71, it has been stated, ordered, my lord, all members, that is Priyanka Maiti, that is the petitioner before your lordship, her husband, father-in-law, mother-in-law will stay at their residential house without any condition. My lord, this is the gift.
Who is the Priyanka Maiti?
The petitioner before your lordship, and she is the daughter-in-law. And the fight is with the my lord, in-laws, because I have been asked to be converted. I have denied, and the order passed by the learned maintenance tribunal is directly clashing with the civil court's proceedings. If those persons are allowed to come to my house, and the second thing is, Abhay Chandra may start again the business at the shop room. So by flouting the order of the civil court, my lord, the maintenance tribunal is asking somebody to get inside the room and the shop room. That is not permissible, because civil court's decision always prevails, my lord.
So what is the problem now? So you
Problem is this.
You are having the order of the sub-divisional officer.
My lord, your lordship, this is the civil court proceedings certified copy.
You are having the page 71, the order is in your favor.
No, that goes against me.
All members, that is the Priyanka, her husband, father-in-law, mother-in-law, will stay in their residential house without any.
That is my house.
Correct.
That house is under pendency before the civil court. And they paid for that. They are not within that house.
So have you challenged this order? The order page 71 you have
Yes,
challenged?
that is the challenge before your lordship.
Where is the prayer for setting aside this order? Where is the prayer for setting aside this order?
Prayer C, my lord.
I have gone to the order prayer.
And also take measure to set aside the order of the subdivision.
Where is that?
Prayer C. page 12.
Sir, is to set aside the order of the subdivision margins of which order dated
That is
nothing.
no, that is the subdivision maintenance tribunal and subdivisional officer conta. Yes.
Okay. So, yeah, who is appearing?
Well, I pay for the
On
state.
what ground you challenge this order? What is the ground for challenging this order, sir?
No ground is mentioned, my lord. This order was passed pursuant to an order of the.
I am asking you.
My lord,
My lord, I am led by Mr. Basu.
my lord, this order, my lord, in that occasion, some difficulties there in the petition I have seen, my lord. So, my lord, a supplementary affidavit, some scope may be given, my lord, the junior advocate has.
If you want to withdraw that, liberty to
Yes,
the fresh.
My lord, instead of-
Supplementary affidavit, you cannot
Improve this case
include
or
all
change.
the facts further. If you want, you withdraw, file a fresh.
Then, my lord, that
Counsel for the petitioner prays for withdrawal of the present petition with the liberty to file a fresh. Consider the submission made by the counsel for the petition WPA 23884 of 2025 is dismissed as withdrawn with the liberty to file a fresh.
Grateful, my lord.
Take the certified copy of the order. It is yes, item number 19. Nobody. None appears on behalf of either of the parties. No accommodation is sought for. WPA number 24039 of 2025 is dismissed for default.
You love to.
और इसमें क्यों आया फिर लगाया ना? बता दो.
Lordship, item 20, I'm appearing for the Respondents Union of India.
Not this one.
Your Lordship, I was seeking time till
Well, I
Friday,
appear
coming
to-
Friday, to file my report.
My lord, I appear for the petitioner, my lord. I am filing the affidavit of service.
What is the prayer?
My lord, non-renewal of passport.
Fresh passport. Fresh passport.
Non-renewal of my earlier passport. It has been expired, my lord. I applied for renewal, but not.
Why?
My lord, 3 criminal cases are pending against me. My lord, what I suggest.
So why you not approach the London?
Then I have already approached one court. They have rejected.
Rejected? On what ground?
Since the grievance against the charges against me is grievance is highly, so the lower court has rejected. What I pray, my lord, let me explain. My lord, the petitioner was a PWD contractor. He was very close to the earlier government. Now he is close to this government, but he is holder of a arms with license. My lord, for that reason, 6 cases of arms has been given against him. My lord, my simple prayer is let my passport be renewed. My lord, each and every time when I will leave the country, I will take permission from the court.
Correct. See, if you are having the criminal case and you are having the passport, you want to intend to extend, first you have to approach before the London magistrate.
In one court I have approached, they have rejected. So by showing that all the other court will reject, what I let them screen my.
That is a rejection order. So if it has been rejection, the order of the rejection, whether it is a writ petition.
No. Yes, I have.
Your Lordship, the notification provides that he has to obtain a NOC for a limited period when the criminal case is pending. And from that, he can apply under 482, not under writ petition.
My lord, I have applied for renewal of my passport.
Correct.
He should call me and check my say and will issue a report that you have to take NOC. But that has not been done.
Your Lordship, kindly grant
Since
me till time till Friday, I'll file my report.
Since
Let them
2020.
file the report. Counsel for the petition respondent prays for time to file report. Let affidavit and let the report be filed by way of a short affidavit by
Fortnight time will be granted. By way of an affidavit, kindly let it be by way of a report
by
by Friday, coming Friday.
by 14th of November 2025 after serving the copy to the Land Council for the petitioner. Exceptions, if any, be filed by 19th of November 2025. List the matter on 21st of November 2025. affidavit of service filed by the petitioner be kept with the
Your lordship has mentioned in by way of a affidavit.
Yes,
that in the
affidavit
form of a
by 14 you file affidavit if by serving the copy to the petitioner, reply if any by 19, let the matter appear on 21st.
much obliged.
Already 21 I appear for the petition. But though this writ petition is against the South Dhamma municipality, but the fact remains an application under 6 of Right to Information Act has not been replied. But what I simply pray, let this writ petition be treated as representation. Let them hear me out and pass a reasoned order.
My lord, I am appearing for the municipal.
Authority can be given a liberty to treat the writ petition as a representation.
Or my lord, directing them to supply me.
When you applied for the RTI, where is your RTI application?
My lord, page 25.
Page 25.
Yes.
Why you are not providing?
My lord, your lordship, my lord, let the respondent number 3, my lord, be directed to reply to that, my lord,
Reply to
RTA
that.
application.
How many trade license has been issued by Dandam municipality in respect of the above referred premises? So why you are not providing this? Affidavit of service filed by the petitioner be kept with the record. The grievance of the petitioner that on 15th of May 2025, the petitioner has made an application before the Public Information Officer, Damdam Municipality, paid for certain information. Where have you paid the requisite fee?
Yes,
Police, in spite of receipt of the application, the Public Information Officer has not provided the. If it is not provided, the appeal provision is there. You could have filed an appeal.
They have not passed any order. They have kept it pending since long.
The petition also made a representation to the Public Information Officer and the concerned authority, but that has also not been disposed of. Considering the above, this court find that no purpose should be served by keeping the present date application, and no purpose should be if the writ petition is pending before this court. According the writ petition disposed of by directing, who is the respondent?
Respondent number 3, my lord.
Respondent number 3.
Right.
The chairman is the PIO.
No, perhaps my lord, the executive officer is the public.
Respondent number 3.
Respondent number 3.
Respondent number 3. The Public Information Officer, Dandam Municipality, is directed to dispose of the application filed by the petitioner dated 5th of May 2025 within a period of 2 weeks from the date of receipt of this order. PN number subsequently disposed.
I am appearing for the petitioner.
My lord, I am appearing for the state led by Mr. Arjun Roy Mukherjee.
The petitioner is come before that she is the Han Muslim. Han Muslim, my lord, backward caste. Yes, my lord, government has issued a certificate, page 27, my lord.
Page 27?
Yes, 27. Mana category B, my lord, Khan Muslim is OBC. Then, my lord,
what is the name of the petitioner here?
Yes, my lord, Rojina Khan.
Rojina Khan.
Rojina Khan. Daughter of Khanna. Yes, sorry. Thereafter, my lord, 2005, Government of West Bengal published a recognized classification for revaluation. My lord, then page.
This is OBC certificate.
Yes, my lord. Page 28, my lord. Then more category A to B2A. My lord, serial number 16. Khan Muslim, A category, my lord.
Khan Muslim, A category.
A category. Kindly,
more backward.
Yes, my lord. 16. MEA.
Yes.
That's why I am apply for online application. Then after verification, the application, they have rejected my application, my lord.
Where is your online application?
Page 37, my lord. Page 32 for my application.
Page 32 your online application.
Yes, my lord. Thereafter, he has taken a hearing and all questions. They have rejected my application and can be very safety order, my lord. Page 37, my lord.
Page 37.
Yes, my lord. Online, my lord. They have uploaded. Rejected, my lord. Kindly got it, my lord.
Rejected does not
Rejected.
belong to Khan Muslim community anymore, as she has converted into the Hinduism, as informed during the document checking.
Yes, my lord. I am not Hindu. Only, my lord, where I am marriage on Hindu's son for special marriage act, my lord. Why I am wrong, my lord? They have rejected that count.
My lord, the contention is that she converted into Hinduism. My lord, had she not been converted into Hinduism, there was no need for her to change her name to Dolly Shordar, which is absolutely a Hindu name. She has also gone ahead and in page number 23.
Affidavit.
No, my lord, only change my name, my lord.
That's why disclose their affidavit. Let them file the affidavit.
My lord, kindly, probably is, my lord. I am the appearing for the school service commission exam, my lord. Probably today's result will be out, my lord. Then probably today's result will be out, my lord.
What result?
State, SSC state. Yes, my lord. So many. Then I am selected, my lord. It is very necessary in my certificate, my lord, for council.
So it has to be decided.
My lord, very 1 or 2 weeks, my lord. Can you decide 1 or 2 weeks, my lord?
Yes, 2 weeks, 1 week.
Yes, my lord, only fixed, my lord.
2 weeks, 1 week.
Yes, my lord, can you fix the date, my lord?
Affidavit.
My lord.
Disclosing all the documents on the basis of which you declare that it says they have adopted the Hinduism.
We shall comply, my
They
lord.
married the Hindu, whether they adopted them Hindu or not.
Yes, my lord. My lord, it is apparent from the, otherwise there was no necessity.
Disclose all the things.
Yes, my lord. I shall.
Counsel for the. You are appearing for all respondent.
Yes, my lord, all respondent, all are state respondent.
My lord, for the state.
For the state respondent. Raise for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter. On 4th of December.
In the meantime, stay of the order, my lord. In the meantime, I will.
Affidavit ऊपर है ना?
4th of December, my lord.
That will appear as 4 orders.
Grateful, my lord.
Item number 23, my lord, I beg to appear for the petitioner.
My lord, in this matter, my lord, I am appearing on behalf of the West Bengal Industrial Development Corporation. And my lord, this matter, my lord, revocation of this, my lord, act by this state government.
May I briefly,
Revocation of?
Lord, may I just briefly make it out, my lord? What my learned friend is perhaps suggesting is that this cannot be decided without affidavits because the virus of an act is under challenge. Now, my lord, there are batch of writ petitions which have been filed. My lord, I have found out one of such writ petition where the coordinate bench, my lord, had taken cognizance of this matter. My lord, usual direction for filing affidavits have been there, and the matter is to be listed on 28th. So my humble submission today is, my lord, the issue canvassed here is for the revocation, declaring that the revocation is bad in law. So, my lord, all these batch of writ petitions may be heard together. My lord, this should be tagged, my lord, with the main, my lord, the primary writ petition, my lord, because the contentions are the same, my lord.
The petitioner has filed the present writ application, praying for revocation of the West Bengal incentive scheme and obligations in the nature of Grant and Incentives Act 2005. It is submitted by the learned counsel for the respective parties. The said act is under challenge in several writ applications and it is pending before the different court.
No, my lord, it was previously before Justice Sinha because Justice Sinha was having the
Where it is?
determination. Now your lordship would have the determination.
It is before this court.
Yes, because your lordship is now having the determination of Justice Sinha, my lord. And it was Justice Sinha, my lord, had fixed the matter on 28th of November.
The application and the same is pending before this court. This court. So you file affidavit.
They will file, my lord.
Let affidavit in opposition be filed within 2 weeks. Within 3 weeks.
That would perhaps exceed the time limits, my lord, because if we have to file a reply, may it be 2 weeks and 1 week, so that we can, my lord, come at 28th November.
That will come on 14th. You inform them, then all the matter will be taken.
My lord, 14th.
3 weeks. Reply, if any, they have to be filed within a week thereafter. Release the matter on 5th of December 2025.
Well, I was only praying that, my lord, both the.
That's why that matter come on that day. On 21st. If it is
then your lordship will give me liberty to mention, my lord, that so that it may be tagged along, because the issue, my lord, is same.
The parties are at liberty to mention the matter for analogous hearing of all the matters, all the connected.
Because the issue is same, my lord.
All the connected.
My lord, may I file the affidavit of service?
Affidavit of the kept with the report. Yes, next.
Grateful.
This is my application, Mallet.
I'm being led by Mr.
Mallet, I'm challenging, Mallet, an order passed by the MSAB Facilitation Council, Mallet, of Cuttack, Mallet, whereby, Mallet, an order has been passed, Mallet, which is contrary to the act itself, and hence I say, Mallet, it needs to be quashed. The point is very, very small point, Mallet. Mallet knows under section 18 of the MSME Act, Mallet, the act provides that there shall be a conciliation. If the conciliation does not survive, there has to be a specific termination. And after that, Mallet, the Arbitration Act is invoked and arbitration starts. In this case, Mallet, on conciliation, Mallet, no termination of conciliation, no reasoning, straight award.
Have you served the copy?
Mallet, I was seeking for dispensation under 26A, Mallet, but if your lordship, Mallet, I am obviously bound by your lordships. Lordship, I'll serve, Mallet. I'll serve and come back. Mallet, may I come back by Tuesday if it's, we can serve by.
No problem. Counsel for the petitioner is directed to serve the copy to the respondents. Serve the copy of the writ application along with the documents to the respondents and to file affidavit of service on the returnable date. Release the matter on 11th November under the heading urgent motion.
Very grateful, man. Very grateful.
My lord, I am for the petitioner. My lord, actual date is, my lord, fixed on 12th, my lord, 12th November. But my lord, today the matter is
12th November?
12th November, my lord.
It started on 7th November.
My lord, the service has not yet been completed, my lord. My lord, one more
12th.
thing. Yes, my lord. One more thing, my lord. In the affidavit, my lord, some paragraphs are not put out, my lord. Kindly leave may be granted to put the paragraphs, my lord.
What? Paragraph? Addition of paragraph?
No, my lord. My lord,
Correction in the affidavit?
Affidavit, my lord.
Rectification in the affidavit. So how it was affirmed?
My lord, by mistake, my lord, some paragraph.
Counsel for the petition submitted notices have been served upon the respondents by informing the date of hearing on 12th of November 2025. The counsel for the petition further submit that in the affidavit portion of the present date application, the paragraphs has not been correctly mentioned, and she prays for leave to mention prays for mentioning of the paragraphs in the affidavit portion. Leave is granted to the petitioner to mention the paragraphs in the affidavit portion in course of the day.
Yes,
in course of the day. Let the matter appear on 12th November 2020.
I am grateful.
Lordship, for item number 26, I am appearing for the petitioner. My lord, service is not yet completed to the banks, my lord. My lord, we have served, but the receipt is not yet.
What is
My
the
lord,
prayer?
My lord,
You are appearing for?
I'm for the state, my lord. My lord, my prayer are to immediate defreeze of the Axis Bank account and direction to consider the representation made by me to the Axis Bank on 17/10/2025.
Why it has been freezed? There's any criminal case?
My lord, no criminal case. My lord, nothing. Only upon a complaint which has been done by one of our partner without any notice to us, without any verification, my lord, they have
The
freezed.
partners have been made a past party here.
Yes, my lord, respondent number 6 is the,
Affidavit is not completed.
no, my lord, my lord, kindly keeps it on Monday as urgent motion only, my lord, so that it can be heard. My lord,
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 12th November.
my lord, kindly keeps it on Monday, 10th, my lord.
Will you be able to file the affidavit?
Yes, my lord. My lord, only the receipt is not yet.
On 10th November 2025.
My lord, kindly retain its position, my lord.
It is directed to file affidavit of service on the returnable date. Yeah, that will be a new motion.
Much
With the partners, madam, but no complaint is submitted to the police. Police has nothing to do with this matter.
Okay, let us see. Yes. The petitioner has filed the present application being CRAN number 862 of 2020. Yeah. ये क्रैन डिस्पोज ऑफ दिखाता है क्या? क्रैन डिस्पोज ऑफ हुआ? आपका तो कुछ 862 49 2018 है। In spite of service of notice upon the petitioner, none appears on behalf of the petitioner. Even none represented the state. For the interest of justice, the case is adjourned. Let the matter appear on 19th November 2025. It is made clear that on the date fixed, if none appears on behalf of the petitioner, appropriate order will be passed. একটা রেকর্ড করেন। It is fine that the CRAN 1 of 2020 and CRAN 2 of 2020 already been disposed of. Accordingly, CRAN above CRAN numbers be deleted from the list. None appears on behalf of either of the parties. In spite of none appears on behalf of the petitioner in spite of service of notice. Let the matter appear on charge date the same. Yes, next.
My lord, I am for the petition. I am praying for not today, my lord.
Why?
My lord, actually,
1997 matter.
my lord, my senior asked me to pray for a not today as he forgot to take the brief to court, my lord.
What is the matter?
I am not acquainted with the matter, my lord.
The senior only told you to take adjournment. 302.
Tomorrow he will do, Monday he will do the matter, my lord, positively.
The accused person so are found not guilty. They appeal against. Why before this court? Not guilty for the offense and hereby acquitted. Who are you? Who has challenged the order of acquittal?
My lord.
Who are you?
My lord, I am not acquainted with the matter at all.
As per the
I have
record made by the counsel for the petitioner, case is adjourned. Let the matter appear on charge date the 19th November 2025.
much obliged, my lord.
Take your lordship, and for the petition, I'm led by senior advocate Himanshund in this matter. Your lordship, the petitioners in this matter have prayed for quashing of the impugned proceeding, as well as for setting aside of the order dated 31/2000 of passed by the learned magistrate, whereby the learned magistrate took cognizance under section 306 of the Indian Penal Code without examination of the complainant and witnesses on oath, which is mandatory under section 202.
The case is pending.
Yes, your lordship.
Which year FIR?
FIR was lodged on March 20, 1989, your lordship.
89.
89.
So still the matter is pending.
Yes, sir.
Which court?
It is pending before the learned magistrate because the petitioners have prayed for quashing of the proceeding and challenge the as well as challenge the order dated.
Where is the order dated? Which
the
order?
order is January 30, 2000.
Huh?
January 30,
2001.
2001, lordship.
30 January 2001.
Second last page of the petition, if your lordship kindly takes up the petition.
Factor combination present by petition.
The ordering portion is the internal page 2, your lordship.
You challenge the cognizance.
Yes, your lordship. The learned magistrate took cognizance under section 306 of the Indian Penal Code, whereby
Still the matter is pending 2001.
Yes, your lordship.
So ready?
Yes, your lordship.
Yes.
The prosecution case in a nutshell is that the deceased.
Which was the state?
Was it calculated at
2001. Not a new one. Huh?
no service? And the effect of fresh services.
Your lordship so desires, we can effect fresh service upon the state.
What and you also take the Instruction, what has happened to the lower court?
The stage of the case.
Stage of the case. They have challenged. Is there any stay?
Yes, your
Is there
lordship.
any stay? By which order there is any stay? I am vacating that.
Lordship, there was
2001, you have taken the stay and roaming here and there, and now 2025.
Lordship,
I am
kindly-
vacating the stay. Let the trial court proceed, and this court also proceed.
Lordship,
You
kindly
acquitted,
calls
you will
for a
acquitted.
report.
No problem, madam. 2001, you are playing with the court. File the criminal division challenging the cognizance and lying there, which was dismissed, then condonation of delay, then restored, then lying there.
The matter came up for hearing for the after restoration for the first time before your lordship. After
2001 is the first time. I find there are several orders.
after restoration of the application, it has come for hearing for the first time before your lordship.
Counsel for the state press for time. According case is adjourned. Let the matter appear.
My lord, let them serve a fresh copy upon the public prosecutor's office.
The petition is directed to serve
My
a fresh copy of the revisional application to the learned counsel appearing for the state in course of the day by tomorrow.
From the court office of the public prosecutor.
By tomorrow, let the matter appear. Police of the counsel for the state is also directed to take instruction with regard to the stage of the case before the learned trial court. Learned trial court. List the matter. List the matter as specific matter. List the matter as specific matter on 20 November 2025 at 2 p.m. It is made clear that no adjournment shall be granted.
Grateful, ma'am.
If the petitioner failed to appear, comma, the matter will be
Give me a
taken up
copy
in
then, please,
absence of the
so that I can give it.
Your lordship, I'm for the petitioner. Your lordship, it's a very old matter. Kindly allow me some time to connect with the client.
Now I will take all criminal matters every day for 2 hours. 2 to 3:30.
Lord, even I need a copy of the petition because the last order says Shumitra Panja has died. The petitioner report is to be filed for the end of the state.
Copy of the instant order sent to the office of the learned prosecutor. High Court memo number so and so with the request to forward the copy.
Substitution of file
It is forwarded.
Your lordship, a substitution petition was filed. Report was filed.
Report. I am for the opposite party number 2, my lord. Report was filed. Thereafter, they filed a substitution petition. So that is pending.
Substitution of?
Substitution of the company.
Your lordship, the petitioner died and the
Who is the petitioner?
petitioner was Shumitra Paja.
Who is she? Whether complainant or what? Accused.
She is the complainant.
She is the complainant.
My lord. So her daughter is willing to pursue the matter. So a substitution petition was filed.
So have you served?
Service.
No. I have not been served with the copy. I am opposite party number 5, the substituted respondent. I have not been served.
The
Yes, sir.
counsel for the petition is directed to serve the copy of the application being CRAN number 1 of 2024 to all the respondents. All the respondents by 12th of November 2025. List the matter on 20 November 2025.
20th November.
Next.
Well, 32, the revision filed by the state, my lord. Well, I am for the state, my lord. Kindly keep it only 1 day accommodation, my lord, because it is a very old.
What is the stage of the trial matter? What is the stage of the trial?
Well, let me bring the report, my lord, regarding the stage of
You
trial.
are appearing for whom?
I am for the state, my lord. State has the petitioner, my lord.
I am appearing for the opposite party.
What is the stage of the trial?
I am not being known about the matter because Mr. Basu is the learned counsel, he is the leading counsel. After his instruction, I am appealing.
2003, the matter is pending. The trial has not yet been concluded.
But we are here for challenging the order of discharge, my lord.
They are already discharged.
Discharge, my lord.
Challenging the order of discharge of 2003.
Yes, ma'am.
What remains now?
So, my lord, kindly give one day accommodation. My lord, we will
Dismissing all this. 2003 discharge now.
the only one day, my lord. Kindly.
What order will get if today the court will pass? Yes, now discharge is wrong. What will do? Your witness
Fine.
witness will be available after 25 years.
Kindly one day because I have the senior in this matter, my lord.
Maybe senior, maybe junior.
I bow down to
Only one
lordship.
question. If this court will set aside the order of the discharge, whether the state will be able to prove the case after the 25 years, your witness will come on dog with the stick.
I bow down your lordship, but my lord, kindly give one day accommodation.
Mockery, all persons have made a mockery of the court. File the revisional application and pending. As per the prayer made by the counsel for the petition, the case is counsel for the petition state. Case is adjourned. Let the matter appear on 20th. Next.
Grateful.
Maybe engage. I am dismissing it. 2004 matter. As per the prayer made by the counsel for the petition, same order. As per the prayer made by the counsel for the petition, case is adjourned. Let the matter appear on 20th November. Huh?
They're not giving the number.
Who? Why?
Original side.
Original side, I can't give any leave.
It's going to come to you, sir, now. It's going to come this case from the judge. It's going to come to you, sir. It is a secret.
How the writ petition? That's why they are not giving the number. You are asking for the rent.
Collect on and give it to me. It's been last 20
Direct to make the payment from 2015 to 25.
Got the payment. They are not releasing those payments. Last 20 years. My father tried so much, but he couldn't do it. Now I'm trying. I'm also not serious. The office is just next door, but they don't want to do it. They are giving payments for 2025, but not the previous 2015. Then the tenancy started.
It is already affirmed. Why you know?
Give the number. They're not giving me the number. I have to give the affidavit of service.
Yeah. Affidavit ho gaya.
Lordship, I have to give the affidavit of service. They have said. So with that, I need the number.
Let my officer will inquire what is the problem. Yes.
The petitioner is a partner of a cafe. But he could not pay due to some circumstances that, as well as the partnership business, he could not pay that and thereafter, right after the notice of dismissal. But now the funding for security deposit of 80 comes to page number 20.
Page number?
Supplementary list item 1.
They have raised a consolidated case on the 4th, the date of research. Okay.
Total amount of 2,55,000.
Which is outstanding.
Yes.
Which is admitted and which has been paid.
You paid this amount?
Yes, sir.
Correct.
Thereafter, they are asking for a security deposit for supply of electricity, and they are saying unless this amount is deposited, the electricity will not be.
Where is the demand?
This is the demand. So they are not reconnecting after payment of the.
Charge for reconnecting the supply. Where is that? Charge for reconnecting the supply at the above address.
2,24,330. And total.
Achha, this was okay. 2,24,332. The total amount is 4,79,000. So you have paid 2,55,000.
বলছি আমি বলে দিচ্ছি
Page number 20.
কোনো কেসে নাই বলে
Yes,
আমি বলে
Page
দিচ্ছি
number 20, payment received of.
that is a 2,55,000. Yes. So your meter not been
আমি বলে
connected?
দিচ্ছি
Yes.
My Lordship, at the outset, first of all, I submit that the regulation which has Lordship demanded that we have already handed over to regular Lordship, kindly keep it in your Lordship side. It will require Lordship.
Yes.
And the second thing is that in this matter, if your Lordship kindly see, though I am not taking this point, asserting this point, he is not a registered consumer. Now, in spite of that, the bill which has been raised, it's a 3-month bill. And if your Lordship kindly see page 20, where it has been specified, it appears from a notice of disconnection. Lordship got that? It appears from a record that you have neglected to pay our bill from August 25, 2025. Admittedly, there is a 3-month outstanding due. If you have already paid the above bill, kindly arrange the present receipt, regional office in such and such. Notice is hereby given if the amount is not paid within 15 clear the Lordship. These are kindly see the next last part of the line of this paragraph. The supply will only be restored on payment of all dues. Lordship got that?
Where?
On that paragraph, starting from
Yes, the supply will only be
restored on payment of all dues, comma, reconnection charge and additional security deposit. Lordship, kindly assert on the, kindly take a mark on that.
Yes.
So additional, we are not saying the security deposit. We have got the security deposit. I will show from the regulation. If required, 12 months out that the bill is there, and out of that a calculation has to be made. It is considering the consumption of electricity. If it appears that it is more than that, then additional security deposit can be demanded, Lordship. That is the regulation within the regulation. I will show that. And now the demand which we have said that he has already annexed, I don't know whether it is legible or not, page 22.
Yes. 2,24,000.
2,24,000. Lordship, kindly see, this is the demand. Page 22.
Correct. 2,22,332.
Lordship, this is the demand. Yes, 2,20,000. That is the additional
Correct.
security deposit, Lordship.
Correct.
So that has been said that he has deposited the consumption of electricity.
Correct.
So for the reconnection, rupees 30 and additional security deposit he has to pay. So for this reason, the connection could not be given. If he pay that amount, we are ready to go into Lordship, kindly see the regulation. Regulation 52.
What is the law with regard to the additional security? Regulation 52.
My Lordship, may I show from the index, because there are several regulations are there.
Okay.
From the index, Lordship can ascertain the regulation 52.
Yes. 53, 57.
Regulation number 52, dated 2nd April 2013.
Yes.
Lordship got that? I'm deeply obliged, Lordship. Now, Lordship, kindly come to page 3. Regulation, that is clause 4.
Yes.
This is the security deposit, Lordship. Now, in clause 4.2.1, 4.2.1, a consumer on his license demand through a notice may replenish the deposit as and when it becomes insufficient. Now, when it is insufficient, then additional security deposit can be demanded, Lordship. Now, it depends upon the consumption of electricity of 12 months. If it is deficit, then only we can deposit. And apart from that, I will want to submit people, Lordship, if additional security deposit is with the electricity company, then with interest, it has to be adjusted with the bill. Now, here there is an insufficient amount. For this reason, this security deposit has been demanded as per regulation clause 4.2.1 of regulation 52, I state of the West Bengal electricity regulation. So within the statutory provisions, this statutory demand has been made, Lordship. This is the only issue, Lordship. Probably my learned friend is not aware about this provision. This has been made. They have made the part payment. Let them make the payment. We are ready to go.
That's correct. But the demand notice which you stated, where you stated that the earlier security deposit insufficient.
But that is the
We are maintaining in
My lord, in page number 21, the
yeah.
is already mentioned.
My Lordship, this is the letter where the demand has been made. না ওই না উনি বলছেন যে তুমি ইনসাফিসিয়েন্ট যে ওটা তুমি চেয়েছো ওটা তো অটোমেটিক this is the automatic generated statement, Lordship. You Lordship knows.
Maybe.
But Lordship says because this is
you are having, okay, suppose she is having you are having a security of 1 lakh and you find that it is if it considers the 12 months considered, it will more than the 1 lakh.
Lordship,
you have to give the details so that the consumer should know. Yes,
I appreciate, Lordship. I appreciate, because in the bill, generally what happened in every bill, Lordship has got the vastness in the bill, in the back side, the security deposit there, that this is the additional security deposit we are hearing, and if there is a deficit, that demand has to be made. Now, this is the case where this notice has been given, that disconnection has been made. Now, subsequently, after disconnection, the authority find that there is a deficiency of security deposit. This security
you do one thing.
Lordship,
I am directing you to, for the interim measure, you provide the electricity connection, you file a short affidavit. What are your claim? You made the claim.
The claim is very small amount. This is the claim amount.
Let you serve the copy to them. I am fixing after 3 weeks. Let on, if this court find it is a justificable and covered under the regulation 4.2.1, it is covered under the 4.2.1, then the court will direct to deposit the amount within certain period, then they will deposit that.
বলছি তোমার সিকিউরিটি ডিপোজিটটা তুমি ডিমান্ড করেছো কোথায়?
consolidated bill দিলাম
হ্যাঁ সেটা তো আপনার দাওনি তো আগে সেটাই may I submit one thing? Matter can be cut short subject to lordship because it will be benefited to the advocate, but I am not on that. But the thing is, matter can be cut short. Lordship, let this demand may be made with the entire breakup to breakup the even if the court direct lordship, the person kindly person.
Commercial executive for the clarification and they will hand it over.
Yes, this commercial executive will make this can only demand টা দিতে বলছে
You have to demand.
এইভাবে না এটা না
So that's why I'm telling, okay, I am not passing an order for affidavit. You, for the interim measure, you can give the connection, make the demand.
Lordship, that
make
will
the
be
demand.
yes.
And if he's satisfied with the demand, he will pay the demand. If it's not satisfied, let's see, file the supplementary affidavit. The court will decide this.
তাই করো
That will be better.
Yes, matter will be correct. I am not on the, I want to cut short the matter. You will.
So, no, if she's not ready with regard to your calculation.
Yes,
then it has to be
certainly.
decided by
Calculation
the
for
authority.
Man,
Then
this,
let me file
but the concerned authority will raise the demand before him,
Yes.
and he has to pay that amount. And if he is not, if he is not satisfied with that amount, the GRO to jete pare.
Because in this prayer.
Or the authority is there any? Or you are any authority?
But that is a billing dispute. That is the authority GRO. Grievance redressal officer. He can approach before the GRO.
Before the GRO.
That can be disposed of.
One thing, my lord, they have only given this consolidated bill and I have prayed for
regulation
bill. My lord, now if they're submitting any supplementary demand or whatever by whatever means, then I have to bring that on record as well through supplementary affidavit.
Then you can see, I will dispose of this rate application, directing you to immediately reconnect within 24 hours, subject to payment, and the amount which they have raised, they will give a separate bill justifying with regard to the quantum, how this amount has come.
Payment of security deposit, that will be.
No, interim, they will raise a fresh bill against you with regard to the why the security deposit is required, additional security deposit is required. If you're not satisfied with the demand, you can go to the competent authority for challenging that order. And if you are not satisfied, then you are liberty to
Yes.
But
the reconnection charges has to be paid. Rule 30.
you have to pay.
I think my learned sister will not fight for that.
The petitioner has filed the present application praying for a direction upon the respondent authorities for restoration of the electric connection. The petitioner is enjoying the electric connection and running the business of cafe
Yes, my lord.
under the name and style of
না আমি বলেছি but they are not the registered consumer, they are
Cafe and lounge.
এই বলেছি আমি প্রথমেই তো
cafe. Full stop. The petitioner is the tenant in respect of the premises in question. You are the tenant.
my licensee.
Petitioner is the licensee with respect of the premises in question and has obtained commercial connection.
Yes, my lord.
And has obtained commercial connection.
বলেছি তো হ্যাঁ
As the petitioner has not paid the electrical consumption charges and accordingly notice of disconnection was issued in the month of August 2025. Full stop. When you issued this notice of disconnection, what is the date?
Oh, notice of disconnection 21st of October.
21st. No. That was the due
Page
date.
20, page 20.
Page 20, lordship. It was the bill of September 2025. The bill.
Date is 9th October.
9th October. 9th October. 9th October 2025. কোথায় পেয়েছো?
Is there will be on.
No.
Lordship find that
Notice of disconnection.
9th October.
9th of October 2025. Directing the petitioner to pay for making necessary arrangement for payment of the due and also inform the petitioner that the supply will only be restored on payment of the dues, reconnection charges and additional security deposit payable if any. Subsequently on 4th of November 2025, the respondents have
এটা কি
bill for an amount of rupees 2,55,332 with regard to the outstanding due and rupees 2,24,332 with regard to the additional security deposit for supply of electricity at the premises of on receipt of the said bill, the petitioner has paid the outstanding due of rupees 2,55,332 but has not paid the additional security deposit of rupees 2,24,332 and has filed the present application. Not deposited it due to which the authorities have not restored the electric connection of the petitioner. Thus, the petitioner has filed the present application. Police. The learned counsel appearing for the authority submit that as per regulation as per WBERC within bracket miscellaneous provisions within bracket regulation 2013 clause 4.2.1 the authority has the right to claim the additional security deposit if it is found that the earlier security deposit is insufficient and accordingly the bill was raised for deposit of additional security deposit of rupees 2,24,330.
Ma'am, with the deepest respect, I'm sorry for interrupting. Generally, I do not. If in 4.2.1, if your lordship kindly see in the fourth from the top, 1, 2, 3, 4, 5, 6th line, sixth line from the top, lordship. The notice, lordship got that? The notice shall also mention that on the failure to deposit the replenishing amount of security deposit
This connection will be affected.
will be affected under section 50 on the act of completion of 30 days from the date of service of the notice under section 1. So, lordship, it is there. Well, so on that basis, we will clarify.
So you raised your claim.
Lordship.
You raised
And
the claim.
lordship, one point subject to lordship. He is not a registered consumer. Kindly record that.
Licensee of the premises in question.
License.
Licensee in the premises in question, running the business in the premises. And running the business in the premises.
Well, this consolidated bill may be quashed in the meantime before they submit.
He submit that if the petitioner will pay the additional security deposit of rupees 2,24,332 from the authorities will restore the electric connection subject to payment of reconnection charges. Counsel for the police. Until and counsel for the party. Peruse the materials. Peruse the materials. Admittedly, the petitioner was in default of paying the electrical consumption charges. Accordingly, notice of disconnection was issued and the electric connection was disconnected. Subsequently, the authorities have raised the bill with regard to the outstanding due as well as the additional security deposit. The petitioner has paid the outstanding dues but has not paid the additional security deposit of rupees 224,332. This court finds that though the authorities have raised the bill for additional security deposit, but the said bill does not reflect with regard to the calculation how the authorities have come to the conclusion that further an amount of rupees 2,24,332 is required to be paid by the petitioner as additional security deposit in addition to the earlier security deposit paid by the petitioner. Considering the above, the writ petition is disposed of.
My lord, kindly may I make one request. My lord, if they are relying on this consolidated bill and giving us an explanation towards this bill, let this writ petition be pending. Otherwise, there will be multiple litigation.
Kindly see,
But if they
I am not on that, but it can be kept pending, but I am not on that. But the provision is that regulation 55 specified in case of billing dispute.
Multiple litigation, my lord. Well, let it be pending and I can file a supplementary towards the explanation.
No, get it. Full stop. This court find that the electricity connection is the essential service and the petitioner is running the business of cafe and has already paid the outstanding due of rupees 2,55,332. There is a dispute with regard to the additional security deposit. Deposit of additional security deposit. Accordingly, the respondent authorities are directed to restore the electric connection in the premises of the petitioner within 24 hours on receipt of the reconnection charges from the petitioner. Petitioner and the respondent shall raise a separate bill with regard to the additional security deposit by giving a details how the security deposit is required to be paid by the petitioner. If the petitioner is satisfied with the bill, if any raised with all the calculation, the petitioner shall immediately within a period of 48 hours shall deposit the additional security deposit on receipt of the said amount. If the petitioner dispute the same, the petitioner is liberty to take appropriate steps before the appropriate forum for challenging the said additional bill, if any, raised by the authority for the additional security deposit. If any representation is made by the petitioner before the concerned authority challenging the order, if any, with challenging the bill, if any, with regard to the additional security deposit, the concerned authority shall deposit the shall dispose of the grievance of the petitioner within a period of 2 weeks from the date of receipt of the same. If the petitioner
Can it be 3 weeks subject to lordship?
30 days, I am taking care of this 30 days.
But that's
30, within
3
3
weeks.
weeks. Within 3 weeks. 3 weeks. 3 weeks from the date of receipt of the application.
Non-disconnection of.
আরে সেটা তো বলা
Full stop. If the petitioner is
judgment তো দেখা
is not satisfied with the order passed by the competent
দেখাও।
authority on the application with regard to the additional security deposit, the petitioner shall file a supplementary affidavit by disclosing the same in the present date application within a week thereafter. This the matter. एक week. This the matter on 10th of December 2020.
In the meantime, they will pay the regular bill also. But that is
made clear that the order of restoration of the connection is made by this court for the interim measure, and if the electric connection is restored, the petitioner shall without fail pay the monthly electrical consumption charges to the authority from time to time.
I'm deployed. And lordship, the thing is, your lordship, for your lordship purpose, regulation 55 3.5.1, while it has been specified in case of any billing dispute, the matter is to be disposed of by the concerned GRO. No, I am showing to your lordship for your lordship basis, your lordship.
उसमें under the heading order कर लीजिए ना, under the heading order.
I have the statement.
Yeah, which, yes. You are appearing for the?
Is appearing.
यहाँ रखना.
Right.
Okay. उसी का तो फाइल क्यों यहाँ रखा पड़ा हुआ है? ठीक ठीक.
As it is an old matter, my lord, I am appearing for state, my lord. I am beseeching before your lordship, my lord, kindly direct the petitioner, my lord, to serve a copy to the my lord.
I am telling all the persons with regard to the criminal revision application, henceforth I will fix a date every week, and if none will appear, the court will dispose of on its own motion.
My lord, what I am submitting, my lord.
Because 1997, 2001.
Absolutely, my lord. That's why, my lord, submitting, my lord. My lord, this is an old matter. All are old matter, my lord. Need to be, my lord, disposed of immediately.
What
my lord,
remains
that's why, my lord, in most of the matter, my lord, there is no engagement of state. Because in that time, my lord, there are different panel. So, my lord, I'm submitting before your lordship, my lord.
Wait, I will
Well,
I will issue the notice.
My
I will
lord.
fix 2 days in a week with regard to the criminal matters.
Kindly, my lord, in those matter, my lord.
Time, if nobody will, either state will come or no, petition will not come, this court will dispose of the matter.
My lord, absolutely, my lord. Absolutely, my lord. That to be, my lord. That
Inform
has
the
to be.
state also.
My lord, we have no copy, my lord. We have no copy, my lord, regarding those matter. We have copy, my lord. We have no problem.
The state submit that he has no copy of the criminal divisional application. Accordingly, the petitioner is directed to serve the copy of the original application along with the document to the learned counsel appearing for the state by
to the office of the public prosecutor, my lord.
I am not concerned with you are appearing. I am
lord,
recording
my-
your name. Tomorrow you will go, then you have the responsibility.
My lord.
The office of the prosecutor, they will keep the file in the table. Then you will say we are not men.
My
You are appearing. You take the responsibility.
My lord.
Let the matter of by 11th of November 2025. This is the matter on 20 November.
Lordship, item number 33, that was similar to 34, your lordship, and kept it on 20th, your lordship.
33, 34 both.
33 and 34 both. 33 I kept for 20th November, your lordship.
20.
Your lordship, this matter.
34, 34 who is appearing for the state?
My lord, in
Same order.
Same order. I will appear.
33, 34. 34, 33 क्या हुआ? हाँ, 2011. Yes, next. Yes.
It's a conviction of 436 of the Indian Penal Code for 7.
Huh?
It's a conviction.
Conviction. Which year?
Conviction. They were convicted in the year of 2005. Is the case of 1989.
2005 he was convicted. The appellate court has upheld the order of the conviction.
Yes, sir.
Criminal court judgment passed by the is affirmed. Judgment of 2002. What judgment of 2002?
Yes.
And 2005 appeal dismissed. Now
Against that
then,
matter, we have filed an
then 2005 revision is pending. So whether he is in custody or he is in out.
It has been stayed by this honorable court. And thereafter, it has come.
So I will pass an order. Let he surrender before the court. He surrendered before the London trial court. He served this sentence. If you are interested, you come. I will hear the Yes, right. Yes, start.
They do not have a copy.
No problem. I will hear you. I will not require the state before me.
We have the copy.
Start. Otherwise, I am cancelling it. I am recalling the order and I am sending it to you. In the
I know one will not be that harsh, but fix up a date.
No. Sorry. If you are not ready, then I am. I will recall the order and let you serve the purpose.
I understand, Manoj. I know Manoj will appreciate that today is the first day the matter has come up with you.
Maybe
we have got the files, but
since 4th it is in the list. Since 4th November the matter is in the list. Tell no, it is not listed. Since 4th of November the matter is in list in my court.
We'll come back. We'll do the matters, Manoj. We are interested.
You do that. You start conviction. What? Show me which evidence the London magistrate and the London appellate court has not considered. Show me that. That is the only thing. Nothing else. Which evidence the magistrate has not considered?
I'll come back, Manoj. I'll assist you, Lordship, and it will be a pleasure for
So total 100 matter I will dispose only by pass an order for adjournment.
No, Manoj.
Then I will send all the matter to the Supreme Court. This is the attitude of the bar. They are not cooperating with the bench. Let the matter go to the Supreme Court. And all the matter will be heard by the Supreme Court by a special bench. They are the expertise.
We will inform my lord.
None single matter the appeal, any of the criminal matter is ready. Start.
There are There are five appellants before your lordship, my lord. There are five appellants, my lord, out of whom, my lord, we have the instruction that appellant number 4, that is Arjun Kumar, has expired.
Who has filed the, all 4 are filed?
No, my
This
lord,
appeal is filed by?
5 appellants are there before your lordship. Out of whom, my lord, appellant number 4, Arjun Kumar, to our understanding, my lord, he has expired.
Correct, no problem.
My lord, the persons who will be there is Mongol Kumar, Bhajan Kumar,
Mangal, Bhajan and Mathan.
Mathan and Pahadi.
Correct.
These are the, my lord, 4 appellants who will, my lord, be pressing before the application of your lordship. Now, my lord, the conviction was under section, my lord, 436 of the Indian Penal Code, related with section 149 of the Indian Penal Code, and was for 7 years. And there was a fine of rupees 2002. My lord, the matter was the initial judgment was passed in the year of 2002, and wherein, my lord, we preferred an application for. We prefer an application.
Where is the order of the magistrate?
My page 40. Page 40 of my application.
Page 40.
The question is.
Crane 1 is disposed of or not?
Crane 1 is disposed of, my lord.
Disposed of. So, but you have not corrected the order. And not corrected the cost title. By which order?
My lord, Cran 1 and 2 both are disposed of in 15th of January 2025.
15 January 2025.
Yes.
But the magistrate court order.
That is a restoration. Delay is a law, restoration.
My lord is saying the main file.
No, no. The Can 1 is with regard to the restoration.
Cran was for the restoration.
Okay, okay, continue.
Now, should kindly come to page 40 of my application. I have annexed the, my lord, order, initial order of conviction.
Yes.
But to prove the case, my lord, the prosecution examined as many as 20 witnesses. 20 witnesses, my lord. Out of whom, my lord, PW1, my lord, has got the LCR, my lord. Now, should kindly see PW1, my lord.
LCR कहाँ है? आधा फाइल क्यों आया? जब नहीं आया तो लिस्ट क्यों की आप लोगों ने? जब टोटल रिकॉर्ड नहीं है तो लिस्ट क्यों हुआ? तो लिस्ट क्यों हुआ जब आप फाइल है तो? यस. You are having English language or Bangla language? Yes. What is the evidence? Yes, read. The incriminating portion, where the implication?
They say it could not be the fire, there was a promotion.
What?
Promotion. There was a promotion in the and thereafter what happened? At the practice process, there were total 1, 2, 3, 4, 5, 6, 7, 7 accused persons at the initial stage. But allegedly, the accused persons entered the village, set fire to few of the houses, and looted the paddy. Now, my lord, the evidence of PW1 says that they have sustained a loss of rupees 7,000 to 8,000 rupees due to such looting and setting of fire. Now, my lord, if your lordship, when I'll portray the entire matter of your lordship would find that none of the how many houses were actually, my lord, gutted and were set on fire, or the houses, which house belonged to whom, that has not been identified by anyone.
There is no fire report.
Their fire report is to the only
Fire officer is not
Caesar
agreed.
list. Sir,
Fire officer is not been examined.
not examined.
Not
Fire officer
examined.
has not been examined. Now, my lord, whose house was gutted? The exact place of occurrence has not been, my lord, pointed out by the prosecution. My lord, whether the houses which were set on fire, whether that falls, whether that was a residential house or not, though has been stated by one the complainant that it was his residential house, but my lord, that has not been pointed out by anyone. Whether that was a residential house or a house out or a place where outside the house has not been, my lord, set out by the prosecution, could not be established by the prosecution beyond reasonable doubt. Now, my lord, my lord knows that to establish a case of 436, that has to be a residential house. If not, this could have come under the provisions of section 435 of the Indian Penal Code. Now, my lord, what I need to do, my lord, I need to, my lord, give you lordship a copy of the evidences so that, my lord, we can discuss about the evidences. If I can, my lord, read out it for your lordship.
The revision first you show me the judgment where the London magistrate, this is a judgment and this is the evidence, this has not been considered. That's all.
Evidence
Not it is
in
not
that
a, this
event.
is not a appellate court.
Yes.
In the revision, you might have been, this is the portion of the evidence
My
of
lord.
the witness, and this has not been considered.
My lord,
This
correct.
is the Caesar memo, which favor the petitioner, but has not been considered.
But we need to see the
That are the two
along with
things have to be
three
given.
things, my lord.
Not in the revision
Judgment-
application, all the evidence is
No,
to
no,
be
all
read,
evidence,
charge
my
is
lord,
to be
sorry, your lordship. Judgment relied upon evidence, corroboration with the LCR.
That's only.
These three things, my lord, we
Which portion of the evidence in London magistrate or the appellate court has not considered. That's all.
my lord. May we see the
That is the perversity.
may we see the lower court record for a moment, my lord?
Record and order. It is fine from the London Council for the petitioner has argued the matter for some time, but it is found that the trial court record is not on record. Accordingly, the department is directed to place the trial court record before this court. List the matter on 20th November 2025.
Which term, my lord? 20th November, my lord.
Yes, next.
I have a file at the end. LCR to people for
I have the statement.
I have a file the please. Take it.
Matter of 2005, my lord.
Yes.
There is no service upon the state, my lord.
Service might have been, but you are keeping change.
In the year of 2005.
Correct. You are keeping change. The petitioner, every time the petitioner has to serve the copy. You are taking the charge. You are not taking what are the matter pending before the earlier advocate. What is the procedure you adopted once you have been the panel is changed?
Panel, my lord, has been changed while in the
That's
year
why once the panel is
2007,
changed, you are not taking the details of the gist. What are the order? PP is not taking all the details from the earlier advocate and giving to you.
2000, if it is, my lord, not so old matter, my lord, we are, my lord, able to, my lord, collect. My lord, it is a matter of, my lord, 2005, my lord, 20 years back, my lord. That is the reason I am visiting my humbly submit to your lordship, my lord.
Which was the petitioner?
None appear, my lord.
Nobody is there.
Nobody is there.
Let me decide on merit of the court on its own. You ready?
My lord, we have no
Lower court record
to
नहीं है.
assist your lordship, my lord.
Lower court record है.
My lord,
क्यों ये सब लिस्ट किया आपने जब लोअर कोर्ट रिकॉर्ड नहीं है तो टाइम वेस्ट करने के लिए तो लोअर कोर्ट रिकॉर्ड नहीं है वाई हो लिस्टेड none appears on behalf of the petitioner. It is found that lower court record is trial court record is not lower court. Trial court record is not on record. The department is directed to place the trial court record on before this court on 20th November 2025. Yes. हटिए बुलाइए बुलाइए लिस्ट में रखे तो क्या करेंगे
नंबर 37 অরিন্দম সেনজি
इसमें भी नहीं है सेम ऑर्डर कर दीजिए सेम ऑर्डर लोअर कोर्ट रिकॉर्ड नेक्स्ट
38
सेम ऑर्डर ट्रायल कोर्ट रिकॉर्ड यस नेक्स्ट
Order কোনো pass হয়েছে দাদা? Order pass
सेम ऑर्डर ट्रायल कोर्ट रिकॉर्ड नेक्स्ट
I'm for the state my lord.
But I am for the petitioner in this matter. My lord, this pertains to non-payment of provident fund dues, which has been subsequently
CRR.
CRR. My lord, this is a quashing application. Charge sheet has been filed. Now, my lord, I have come for
when the
quashing.
charge sheet was filed sir
My lord, charge sheet was filed long back.
now we are on
My lord, I tell your lordship the date.
2008 17 years passed
Yes.
and you are enjoying by filing the application before this court. What is the stage of the trial?
The trial has not started.
Because you filed the costing application.
There was a stay order, my lord, and there is no offense disclosed.
So I am vacating the stay order.
There
Let
is
the
no
trial
offense disclosed. Let me
I
address.
might be not after you face the
Let me
trial.
address your lordship on quashing.
17 years not a joke, sir.
My lord, it is not my fault. My lord,
No?
matter never listened.
What is you are not follow? Any show me any order you mentioned the matter for hearing of early hearing. Show me any order.
My lord, the lower
And you
courts
mentioned the
are-
matter for early hearing, but the court, due to the time the court could not be taken up the
courts
matter.
are also burdened with lakhs of matters, my lord. It is not
Court
that
is
on
not,
mere,
this court is not burden.
on mere mentioning matters are taken up, my lord. It's not.
Show
like
me
that.
the order whether you mentioned the matter, but the court has not
Now
taken
it
the
is
duty.
before your lordship. Let me address.
So I am vacating the stay order. Let the trial court proceed, and you
Lordship hears
also
me
proceed.
whether
If
any
you-
offense has been disclosed
Maybe.
or not.
So you file an application before the trial judge if offense is not paid at the time of charge.
Invoke the inherent jurisdiction of this honorable
Why?
court.
Why do you
There is no offense disclosed.
Okay, you
The
file an
question of
application for
facing
discharge.
trial, my lord, does not arise.
What is the section?
Only 406 non-payment.
406 the magistrate have the power to hear the matter.
Kindly seize my documents first. There is gross suppression of material fact in institution of the case itself.
The state.
But I'm for the state my lord.
Okay, yes. Where is the complaint?
Page 15, annexure P2.
Page 15.
Yes.
And I don't have CT right now my lord. Can it be?
You are satisfied with the accused roaming here and there after filing the charge sheet? You have also not made any endeavor.
The relevant part is, my lord, page 19.
Huh? Have you filed an application for vacating the stay?
Stay was not extended.
My lord, the relevant.
So have you proceeded?
My lord, I have to take instruction my lord.
Then?
Kindly give us
No, no, nothing has happened.
Where is the stay, sir?
My lord, kindly comes to page 19.
Yes.
Last paragraph. During our inspection.
19.
Yes. The last paragraph.
Yes.
During our inspection of the said establishment on 13/6/2001, it has been noticed that the employer, Sushil Kumar Bagla, has deducted as per details enclosed a sum of rupees 2,92,509 from the wages of the employees as the employee's share of provident fund contribution for the period from March 98 to December 99 and have not deposited the amount with the statutory fund in violation of section 6 of the Act, read with para 38 of the Employees Provident Fund Scheme. Non-remitting of the Provident Fund money after deducting the employee's share from the salary wages tantamount to an offence of criminal breach of trust as defined under section 405.
So
Now,
this
Lordship,
petitioner is employee.
Petitioner is a director. 2.
Director of?
And the first petitioner is the company itself. Now, my lord, kindly comes to page 15 once again. Sees the date of registration of the case. 24/9/2001.
No, if you have not deposited this amount.
I have. Prior to FIR.
Sir, I am putting you on question whether any EPF case has been initiated under section 17 or 14.
No. Only 406 has been initiated.
The APF commissioner has not initiated any
No.
proceedings. How this proceeding has been?
No, this is by
Who is
the
the complainant?
complainant is the PF authorities.
PF authority has made a complaint, but they have not initiated the PF.
No
You are
section
having
40,
the
yes.
EPF Act.
Section 14 proceedings has not been initiated. Directly
Section 14,
406.
Section 7, I think. I
7A is the adjudication. This is the
Adjudication.
book. And 14 is the penal offense.
So they are not initiated.
No.
And the criminal case has been-
Directly an FIR. Now, my lord, kindly sees, comes to page 15 once.
Yes.
This is the date of the FIR. 24/9/2001.
24.
Now, lordship kindly takes up.
Where you got the date?
My lord, this is
page 15.
Page 15.
Yes.
First is, my lord, first information report.
Hmm.
District South 24 Parganas, Subdivision SDJ Malipur, PS Bhawanipur, year 2001, FIR 321. Then, date is 24/9/2001.
24/9, yes.
Yes. Now, lordship takes page 12.
You are going back.
Yes.
Hmm.
These are the payments made by me.
June 2001.
Yes.
But the additional document can be considered by the court at the time of
This
that.
is a document given by a bank, which is
That's
prima
correct.
facie evidence according to Banker's Book of Evidence. I can
That's
satisfy
correct.
your lordship on that.
Not satisfied.
Yes.
At the time of hearing the quashing application,
My lord,
then
a
whether the additional document can be
a
looked
document
into.
of unimpeachable nature and sterling quantity can always be placed reliance by a court. I can show you judgments on that.
When
Padis-
which year judgment?
TN Padis case and subsequently followed by recent judgments also. This is a document which is issued by the bank, not my document, SBI, that I have made the payment. So lordship kindly takes up the entire payment has been made prior to registration of the FIR, and this has been suppressed. So the FIR itself suffers from gross suppression of material fact.
Investigation completed.
Yes, charge sheet file.
Where is the charge sheet?
Charge sheet, I said page, my lord, 20. Nothing has been done in the charge sheet also.
Where is the charge sheet?
Just in a lackadaisical manner, charge sheet has been filed. Page 27. এটা তোর ভবানীপুর.
You have been arrested? No.
I was on anticipatory bail.
So whether you have not produced the document at the time of your interrogation?
My lord, they have
During
never come in
investigation?
a lackadaisical manner. They have done
And
this.
you got the anticipatory bail. Police has submitted a charge sheet. You
How
file
can
the
police do,
application
my lord,
for
without
quashing the
interrogation?
FIR, and you are enjoying for the last year.
My lord, how can
24 years.
police, I'm asking it to myself, file a charge sheet without proper investigation?
Show me the judgment whether the additional document can be considered at the time of quashing of the FIR.
That I am not carrying. Now I am carrying the judgments where if payment is made,
No, payment is made now. I am
then
not
there
mentioning.
cannot be a proceedings under 406, 409.
Where is the judgment whether you have the at the time of proceeding at the time of hearing of the the additional document?
Then I will come back with the
consider.
judgment, my lord.
Today is the fixed for hearing.
My lord, this is, my lord, I have not brought that judgment because
That is the only question.
my lord knows
Your
much.
case is that you have paid the amount.
My lord knows much better than I do that a document which is of unimpeachable nature and sterling quantity, court can always look into while.
Who will decide that is unimpeachable?
This is a SBI document, my lord. Then we have to doubt the correctness of a document provided by a bank.
Go and prove in the trial. Go and prove before the trial court.
My lord, then I have to bring Banker's Book of Evidence also. Section
Yes,
6 says
the trial, before the trial
any
court.
document which is provided by a bank is a sacrosanct document.
Correct.
And that is prima facie evidence also.
Maybe that's why you prove
My
that.
lord, kindly
before the
gives
trial
me
court.
opportunity to bring that. Keeps it next Monday, my lord, I will bring it.
No, you have today is the fix. All matter like that cannot be adjourned.
My lord, I am not adjourning. I have substantially submitted, my lord. substantially submitted. Now, if your lordship is asking for a particular document, that opportunity should be given.
I am not asking for the document. You have stated that you
my
have,
clients
you have
are-
a judgment which shows that during at the time of hearing of the 482, additional document can be considered.
My lord, this
Show
is
me
sa-
the judgment of
my
the
lord,
Supreme Court
why
that
have
the
said-
just additional document
But
can be
all these
considered at the
judgment
time
which I
hearing
have
of
brought,
482.
which I have brought, only word of mouth that payment has been made and document shows this court has quashed FIRs. There are
Maybe.
10 precedents which are in my hand.
Now the scenario has totally changed.
No, my lord, the scenario has become better with Haji's case.
That's what I'm telling. So
Now,
if it is better, you show.
now court has said that court has to read between the lines and the surrounding circumstances while disposing an application under 482.
The
Lord,
counsel
kindly-
for the petitioner prayed for time. According case is adjourned. Let the matter appear on 19th November.
My lord, kindly makes it part heard. Lord, she was heard me.
Yes, next.
But can I take back the book?
Yes.
Forty-one, my lord, I appeal for the complainant.
Yes. Who is for the petitioner?
Lordship, the restoration application.
Restoration application.
Yes, Mr.
Who has filed the restoration application?
For the petitioner.
Who is appearing for the petitioner?
As per the order dated 4th July, Mr. Jyotirmoy Talukdar and Mrs. Triptimoy Talukdar.
Correct. Where is?
Lord, if they do not appear, my lord, it is my prayer that the application be dismissed. The CRR, my lord, is of 2009. There was a stay granted in 2010. Thereafter, the matter of
What is the divisional application?
Lord, the revision
138.
Yes,
So cause as to why the impugned proceeding. You are appearing for the complainant and you are sleeping over the matter since 2009.
there was a stay, my lord,
What answer you are going to your client?
but I was not there.
Because the pending before the High Court. That's all. 138 for complaint. And you are sleeping. When the restoration, not there is no revisional application. What step you have taken before the trial court?
My lord, there's a different advocate in the trial court, my lord. If my lord wants, I can file an affidavit on the next.
But
regarding the status of the trial court.
Once you are holding the brief, you know each and everything of the trial court records.
Lord, I checked online, Lord, records as per
Online, you will not think, you will not get anything. Shocking. 138 and you are appearing for the complainant. And 2009 it is pending before the court. What answer you are giving to your client, sir?
that I only had the instructions to appear.
And it is dismissed. By which order it was dismissed?
Lord, order dated 26th August 2021.
21 it is dismissed.
Yes, ma'am.
And not restored. And you have not taken any step before the trial court for
Lord,
consent.
I'm not aware of the steps taken in the trial court.
What steps you have taken?
Lord, I'm not aware. If my Lord wants, I can file an affidavit on the next day.
Affidavit you want, what is the stage of the trial? Then I will
Lord, I'll
direct
take
the
instructions.
trial court.
I'll take instructions, my Lord.
Stay of the further proceeding.
But I am for the petitioner, the learned advocate on record who is appearing with me in this matter. Because of his illness, he could not come.
I am, you are already dismissed. I am directing the trial court to continue and file a report before this court.
But it has not been
It is dismissed for default. And your restoration application is pending.
Yes, madam. The
Yes, the restoration application will let the trial court continue and you proceed, you continue with your restoration application years together.
Madam, kindly appreciate, madam. Today, because of his illness, he could not come.
Huh?
Because of his illness, he could not come, Millet. He is seriously ill, Millet. That's why I am requesting your lordship. Otherwise, I would not have. And the legal issue is involved, Millet, because this proceeding is not maintainable in view of the bar content in the act itself.
So why you are not pressing 2009?
Millet, initially, there has been an interim order. Thereafter, it has been dismissed for default. Millet, we have filed the restoration applications, and that is pending. And Millet, thereafter, the matter could not be taken up for hearing. Lordship, kindly fix any date for hearing. I will address your lordship, Millet.
As for the submission made by the counsel for the petitioner, case adjourned, let the matter appear on 20.
Item number 42.
My lord, 42, my lord, I am appearing for the opposite parties through online. I am led by the senior counsel, Mr. Shandipan Ganguly.
Yes.
My lord, I am appearing for the petitioner hearing.
Yes.
What happened in this case? There is a case under section 420 and 13(1)(d).
420?
13(1)(d) prevention of corruption. A 2K case, credit loan with some false document. The case has been started. Subsequently, during pendency of after charge sheet, during pendency of this case, my lord, file a discharge application. That discharge application, learned judge called for a manager. In the meantime, paid the entire. That's why manager called and evidence has been taken and discharged the opposite party number 1, 2, and 3. Again, even if offense has already been completed, even if paid the money, the offense cannot be go out. Several Supreme Court decisions. In spite of that, learned judge discharged the accused persons and only recorded the one witness, called for a manager, whether he has been paid or not, and discharged from this case. Against that order, CBI
Lord, my land from Lord is not seeing your lordship on merits. No, there's a substantial delay, Lord, which has to be first condoned, Lord. And Lord, we had prepared an affidavit, Lord, which
Delay has already been
gone.
Yes, on 13/10/2023.
Oh. Already condoned, sir. This. Oh, Lord, I was not aware of the condonation of delay, Lord.
Now the time now, application.
Yes, Lord, we would not need this. This is not coming up after a long time. Lord, we'll need little time.
Regarding the restoration application, it was dismissed, not the main application. Main application was not allowed. Tran 1 is not allowed.
Oh, so not their application was dismissed for default. Not the restoration delay was condoned, not on in the main matter.
No, 13th October 2023, condonation was allowed, and the divisional application recalling the order dismissal.
No, dismissal order, no, that is
restoration application stand allowed. The criminal revision is restored.
Tran 1 is not restored.
So, Lord, Tran 1 Milord is for the condonation, but in filing the main proceeding. Milord, this was for the restoration part, not in the main. Tran 1 Milord has not been allowed yet.
Application under section 5 of limitation has been taken up for hearing for 275 days. That was allowed.
No, that is for the restoration purpose, Milord.
Restoration.
Yes.
Now, then the application for restoration of criminal
Yes.
revision is
So, Milord, the main proceeding stood restored, but Milord, the main proceeding itself, Milord, is barred by limitation. Milord, so, Milord, the condonation of that, Milord, has probably not been allowed. Milord, maybe look at the records, Milord, and come back. Probably that has not been allowed.
No, criminal revision application restored is in original file.
Yes, so Milord, should restored, Milord, so it will be restored with the section 5 application which they had filed. So, Milord, that has to be Milord first decided. Milord, the main application itself was barred by limitation, Milord, for which there is a section 5. Milord, Cran 1 is there.
Cran 1 for what?
For condoning the delay, Milord, in filing the main proceeding.
Condoning delay in filing main proceeding.
Yes, Milord, that has not been allowed. Milord,
1 of 2020. 1 of
Milord,
criminal revision.
The original number, Milord, is 3782 of 2009.
Criminal revision is filed along with the CAN. Along
Yes,
with the
yes. So, Milord, that Milord, Milord, it's very old, Milord. Yes, Milord, 2000.
Go through the record there.
Milord, we will both need to go through the records, but kindly give us time, Milord.
No such recording, nothing.
So far merit is concerned, there is no merit.
Nothing.
Milord, may
Nothing is there.
Milord, the main section.
What is the CRAN number?
Milord, CRAN number 2729 of 2009.
29 of 2009.
2729.
Milord, maybe both not look at the records and come back.
No application. And number 2729 of 2009.
Yes.
Pura they have explained it.
Ah,
There में कोई
2729, only last order is 2013.
Yes, my lord.
It
So
is directed to have a copy of the application upon the
yes, my
opposite
lord.
party.
So my lord, that has not been disposed of yet, my lord. And no, that is not being opposed also, my lord. So
Grant dispose of two application like one is restoration and second is
The counsel for the parties prays for time to inspect the record of the present proceeding. Accordingly, prayer is allowed. Both the parties are
There is a
directed.
delay only 43 days.
Okay, inspect the record. What is
Yes.
the where is the application? Inspect the report within a week. List the matter on 20th. 20.
sure. My lord, may I make a request, my lord, taking advantage of it. My lord, could your lordship not give some little more time now to the original side matters, my lord, at 3 o'clock instead of 3:30? Could it be from 3 p.m.?
Which one?
My lord, the original side matters, my lord. 3:30, my lord, most of the days, my lord, we have a resolution. The matters are not can't be taken for no fault of your lordship. So, my lord,
That's why now going through this criminal list, I also thinking how it is to be adjusted now.
yes. But little bit, half an hour more, but if it could be from 3 p.m. Lord,
Okay,
will
let me see.
I'm grateful.
I will consider.
I'm grateful to you, Lord.
Yes.
Asked us to come at 3, my lord. That
Yes. Hey, Manutosh hai?
they are there, my lord. I've given notice also to the other side.
No, give the order copy.
Order copy to go. My lord, this is the order. Original sir, my lord. Sir, communication ऐसे witness ashwe बोले.
नहीं, ये 10, 10, 11, 12 को 11:30 है ना. 10, 11, 12 हम लोग के 3:30 से हम लोग ये एविडेंस nobody. This is also 2009. He होवे. None appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, the case is shut down. Let the matter appear on 20. Next. Same order. Yes, next. Yes, Mr. Mitra, any matter?
Hello. We just said it's at 3 p.m. Mine the first motion.
3 p.m. 3:30, I think.
3:30. Oh, we were informed by whom? Because the court office is at 3:30 as per the minute.
Yes.
But when I was told since my lord rising at 3:30, the resolution. The officers have resolution.
बोला है क्या? 3 बजे बोला. If parties are ready, then I will take no problem because here nobody is interested to the matters. If both the parties are ready, then I will take the original.
The other side is there. Lordship, I take the other side.
Yes, call. Not today. Next. As per the prayer record, as per the prayer made by the counsel for the petitioner, let the matter appear on 19th. Not today.
Number 48.
I am for the petition.
I appear for the opposite party, my lord. The important situation has arisen.
Sought issue, my lord. Parallelly filing one. Sir, I am petitioner.
No, only.
Sir, I am petitioner.
I am not troubling you. Just only one thing to be brought on record. One of the opposite party, 2 days back, I have received information that opposite party number 2, Mohammad Basiruddin, he died, my lord, 2 days back. So I have talked. That is why. Another thing is that this is, I have not received any death certificate. I have asked the death certificate for that.
You are for the opposite party now?
Opposite party. Both the opposite party.
I am the complaint, I am the petitioner. What had
The
happened?
2 is died.
2 is died, my lord. Your lordship will follow the rest of the procedure according to death certificate. What I am saying is only one line, points of law is there. Parallelly, whether 138 proceeding along with complaint under section 420 or 406 will go on not. My complaint was dismissed on the premise, which was filed under section 420, 406, that you have filed 138 proceeding, so this cannot go on further. On this ground, it was dismissed. Challenging that order, I
Dismissed means your
my
complaint.
was dismissed.
138 complaint was.
No, 420, 406, which was a file.
That is 156.
No, complaint.
Complaint case, 200.
So this was the moot issue while rejecting my complaint. Or challenging that complaint, the order, I filed an appeal. There also, same order was passed. Number my moot point of submission which was there is subsequently affirmed by Honorable Apex Court in a celebrated judgment, that is Sangita Ben Mahendra Bhai Patel, your lordship may aware. This is the first judgment which permitted that 138 as well as 406 or 420 in respect of same check will go on, and that will not come as, or will be treated as double G. My lord, let it be placed. Only this point, your lordship will be coming. I will show the relevant point. My lord, I will first show on what ground it was dismissed. Your lordship kindly come to page 44. The order passed by the London Magistrate. Judgment, the first heading is clear. If your lordship goes to the judgment, then I will. Your lordship, revision. Page 44. Now, relevant portion, your lordship may kindly come when it was dismissed. Page 48, second paragraph, 5th line. 48. Having considered the your lordship is on page 48. Having considered the evidence and material present available on record, both oral and documentary, coupled with the argument as such and such, it will be irretrievable. But this court has to reproduce here that successive 3 delivery of goods to accused without any payment by complaint is out and out a false allegation admitted by written argument. Concealment of the issuance of check by accused number 1 dated 20th 9, 2006 vitiated the whole allegation. His failure to prove by producing sales acceptance such and such were dismissed. Now, subsequently, my lord, kindly come to appellate court's judgment that your lordship will be finding at page number that is not paginated. At page 72, I have annexed both judgment, xeroscopy. Your lordship is on page 72. That is passed by the learned appellate court. Second paragraph I'm reading, my lord. So, learned magistrate 11th court is quite justified in holding that the offence under section 420, 120B of the IPC is not proved against the accused person. They are acquitted and such and such.
Not proved.
First paragraph. Decision by the apex to the country, I am inclined to hold that the present case under section 420 is barred by section 301. First paragraph. Page 72.
I am inclined to hold.
The double jeopardy principles was brought down. Now, my lord, kindly see the judgment which I am relying upon. Same principle was first head note, my lord, I am reading. Criminal Procedure Code section 300.
No, whether the London magistrate has passed an order after the evidence.
Yes.
After the evidence.
Yes. Holding that since I have suppressed the 138 proceeding,
correct,
and if that 138 proceeding is placed on record, that will come as double jeopardy. That is why treating is this case as a double.
No, with regard to the magistrate order, what the magistrate says.
That is a page
available record, both oral and evidence, coupled with the argument as advanced on behalf of the contestant. So, though it will be irritable, but court has not. Court has to reproduce here the successive 3 deliveries of good
Prior to that, page 47, last paragraph. There also this double jeopardy issue was dealt with.
Okay, that will be taken care of it. But if you're not satisfied, you're not prove the case on merit also
Yes.
on evidence.
Yes.
So, but then that observation the court will take care of it. Where is that?
You will also kindly come to page number 47.
The evidence will also say so. Can you come to page 47, third line?
The last
There is no
paragraph.
doubt as to this, sir. You will get your chance, sir. Let me brief. Third line, page 47. There is no doubt as to receive of goods by accused as per receipt dated such and such. This is the observation.
They made a payment of the said check amount.
Yes, and that check was bound. That is why 301 plea was taken. That you are also perusing in 138. So why you are pursuing here? Everywhere, even the second paragraph, middle portion. In the present case, in my hands, as the petition of complaint and evidence record, successively 3 deliveries were made, only on promises. But cross-examination of PW1 313 accused number going to give the complete proof. All delivery paid in court. The complaint, as I already held, suppress this fact of issuing check. Everywhere this check issue has been tracked.
Yes, my lord.
I will come to. Yes, where is the judgment?
My lord, first head note, then I will go to the relevant paragraph.
Come to the paragraph. Which paragraph?
Supreme Court কোথায় রিপোর্ট করেছে রিপোর্টে বলো না কপি আছে আগো
স্যার আমাকে সাবমিশন করতে দিন, এটা
কপি
তো
দাও
রিপোর্টের যে
স্যার
স্যার
দাও না সাবমিশন করো না তুমি করো না আমাকে রিপোর্টটা শুধু দিয়ে বলে দাও তুমি না বললে কি করে বুঝবো না তুমি তো
Admittedly, the complaint had been tried earlier for the offence under punishable under section, the provision of section 1, last 27 paragraph reading. In the instant case, he is involved under section 406, 420, read with section 114 Indian Penal Code. In the prosecution under section 138 NI Act, the mens rea, that is the fraudulent or dishonest intention, at the time of issuance of check is not required to be proved. However, in the case under Indian Penal Code involved herein, the issue of mens rea may be relevant. The offence punishable under section 420 IPC is a serious one, as the sentence of 7 years can be imposed. In the case under NI Act, there is a legal presumption that the check had been issued for discharging the antecedent liability, and that presumption can be rebutted only by the person who draws the check. Such a requirement is not there in the offence under Indian IPC. In the case under negotiable instrument is a fine. If a fine is imposed, it is to be adjusted to meet the legally enforced liability. There cannot be such a requirement in the offence under IPC. The case under NI Act can only be initiated by filing a complaint. However, in a case under IPC, such a condition is not necessary. These are the differences, which was the vital point to differentiate a case between NI Act and a case on the same issue pending under IPC. This was the crux of the submission, and this is the entire reason.
Yes.
My lord, the first one is that the entire episode of trial court concluded after a full trial. Cross-examination. They have stated a claim that we have supplied material. Our client did not pay the amount. Court has disbelieved the entire story. Says that it is an attempt of a person to somehow entangle in a false litigation. If frivolous documents were produced and the person, accused person who is now living, another one has died a few days back. There is no iota of evidence that he is a partner in a partnership firm. All this was examined and cross-examined, and thereafter a decision came. Thereafter, we got acquitted after a full trial. And another thing is that, so for my learned friend has mentioned that one case, check bounce case was there. Why the court has doubted in their conduct in course of the trial that the check bounce case was ultimately, that also was, there was a conviction, there was an order of sentence by way of payment of compensation, no imprisonment. Then they came before the appeal court. Appeal court judgment was there. Thereafter, it's as same as of the trial court in the check bounce case. There was a check bounce case for 24,000. Court has observed that there is a material supplied for the tune of 24,000 only. Court given a compensation for 28,000 trial court. Their compensation was deposited in the treasury of the court, learned court, trial court. Thereafter, they preferred an appeal before the session judge. Session judge has dismissed the appeal, and thereafter they preferred a revision. And revision court had passed an order. The simultaneous matter, if your lordship wants, I can easily, my lord, supply the copy of the order. The entire episode is described. We have also got a favorable order from the revision court in that case. Thereafter, my lord, so far in this case is concerned, he has taken a legal point at the first instance, how it is maintainable or how it is not. I would request your lordship to once go through the observation of the trial court first. Trial court.
So what
kindly see the judgment. Keep it.
What order this connected with this case?
Yes, this is the not this case. This simultaneous case was filed by them due to the dishonor of this check. The entire amount has been paid. After the judgment of the trial court was passed, there was a direction for payment of the entire check bounce amount. We have paid it. We have got this document, paid it. Thereafter, I submitted before this court in course of that revisional application concerning the 138 case. And in that case, court observed that you pay some more amount because long litigation was there, and the compensation amount was increased from 28 to 50,000.
Yes.
We have paid. That chapter is over.
Yes.
So this case practically infructuous because court has clearly observed that it is an attempt for the same offense. We have been vexed in 2 cases. We have been vexed in the 2 cases. That is why my court has said that is the appeal court judgment. I will show first. Kindly
show that this judgment is denying whatever argument is being made by my learned senior.
Kindly look into the impugned order. Judgment of the
whatever had happened, that
judgment of the appeal court. Kindly see.
Not a case for recovery of money. You have issued check. You have not issued check in here.
Court has disbelieved
something. That is why you have issued
court disbelieved the entire.
That means you have committed fraud.
Who committed fraud?
Proceeding.
Don't say the word fraud. It is a fraud on your client's fraud.
That tag I will bear if I be proved on my hand.
Yes.
Madam, kindly see now the judgment, impugned judgment, page number 2.
Which judgment? Trial court or
appeal court? Is a clear case, my lord. Somehow with a painful story, we have suffered from last 2011 to 12, and now it is 2025. Kindly see the last paragraph. I will not travel your lordship so much. My lord, last paragraph I am reading from page number. There is no page number. Impugned order. The second page of the impugned order of the appeal court.
769.
After the charge, both PW1 and PW2 were cross-examined by the defense.
Where from you are reading?
70. 70, I have no number, my lord.
17.
70.
70, not it is.
35 copy as well as yours. That was page.
No, yes. But I am coming to the last paragraph.
Yes.
I am coming from the second page of the impugned order. After the charge, both PW1, PW2 were cross-examined by the defense. Accused person did not produce any evidence in support of their defense, but the trend of the cross-examination of the prosecution witness answered to the question put to the accused in course of the examination under 313, and it reveals that the total denial of the prosecution case. Thereafter, after hearing the arguments for both the sides, so and so, by judgment dated so and so, was pleased to acquit the accused person 1 and 2. Both the accused person was acquitted on full trial. Thereafter, decision with reason. When I peruse the memorandum of appeal, and may I read, my lord? They suppressed this check bounce case, and that is why the court observed, apart from the merit of the case, it is not the whole case.
Yes.
So, my lord, the third paragraph, I am coming in the decision with reasons.
No, with regard to the 71, the learned session judge or additional, whatever it is, additional session judge
Yes.
has considered that twice a person cannot be convicted. He has taken into consideration 301 and 301 of the CRPC.
Yes.
And
Yes.
but where is the judgment of the
Trial,
magistrate,
yes.
whether he
Page
has
44,
considered all
page 44.
with regard to the evidence?
Yes,
It
yes.
is the case of
Full
the
trial.
evidence.
Yes, yes. Full evidence was, I am coming to that.
Where is
Madam,
that the evidence he has not proved the case?
Madam, kindly see page number 45 onwards.
Yes, 45 onwards.
Well, I am reading from another legible copy because my copy is very unclear, my lord.
Where is the observation or the
Yes.
finding that the evidence
coming.
led by the
I am
prosecution
reading, my
failed
lord.
to establish the case?
Yes. my lord. And then, madam, coming from page 40. 40 in my case, এখানে কত আছে দেখি? See the, my lord, kindly see the the first page of the judgment of the trial court. That the last paragraph, after charge, I will also found last paragraph of the very first page of the impugned order of the trial court.
Yes.
My lord, after the charge, both the PW1 and P2 were cross-examined. Have you also got it?
Yes.
And cross-examined by the defense, and the accused did not produce any evidence of their defense, but from the trains, but did not from the defense. তোমাকে বলিনি আমি ভাই, তুমি অনেক ছটফট করছো, একটু থামো। Accused did not produce any evidence of their defense, but from the trains of the cross-examination of the prosecution witness, answer to the question to put to the accused and time for their examination under section 313 CRPC reveals total denial of the prosecution. Thereafter, my lord.
In invoices signature
My lord,
that was
let-
exhibited.
my lord, kindly see.
All evidence discussed, but dismiss on
Let
the
me
ground
submit.
that there are two cases.
Let me submit. Thereafter, my lord, decision with reason comes.
On invoice accused
This-
sign, can you see page
Are
55
to put my lord, kindly allow me.
Please.
My lord, then second paragraph. Let us scan the documents on record. So and so I have already mentioned. Exhibit 1 are the tax invoices, delivery receipts. 1 and 1 is signature of the accused number 1, receipt number so and so is of his signature on receipt of the copy of the dated at the time of the admission of this exhibit 1 by 1. The defense raised the objection. So it was marked with objection, and it was noted both the evidences as well as the document itself. It is also evident from the 1 by 1, exhibit 1 by 1. There is no rubber stamp of the accused company as it is seen exhibit 1 by 2. There is no rubber stamp apart from this former one bears no date with the signature of the accused number so and so, whereas the latter one bears the date. Exhibit 1 shows that the bears the commercial sales tax number ato itself well, not clear that the complainant is or was a payee of the commercial tax. The only case of the complainant is that the accused has received so-called goods by the putting his signature. It is their case. On receipt of the copy did not pay the amount. Finally denied. And thereafter, my lord, the one expert opinion was called for. Even
denied the whole transaction.
oh, this is the habit. Don't grow up this habit, please.
Don't read here and there, read entirely.
I
That
think
will
it
make
is was in the well knowledge of the complaint that being so, the said document was sent to expert for decision, and finally their report was reached in the record. But the report is kept intact on the record, and surprisingly enough, no initiative was taken on the behalf of the prosecution to bring the said document in evidence. They did not exhibited the documents of the expert opinion. This conduct of the prosecution when report was called for at their instance, and in spite of the receiving the same on record, silence is taken by the prosecution. Then what was the nicety of calling for such a report? Neither the maker of the said report so far this expert evidence regarding their handwriting was not proved. They failed to prove. Thereafter, my lord, kindly see the very first paragraph. They say, very first paragraph, there was a civil dispute for the entire claim. They got an order from the civil court. I received first paragraph. The civil court at Calcutta, white judgment dated 25th of, have you also got it? The first paragraph. By judgment dated 25th of February 2010, being commercial suit number 35 of 2000, decreed the entire amount in favor of the complainant, which has a binding effect. Though they have got a degree. They have got. Oh, if they file a civil, if they file a civil suit,
criminal case, it was not
if they have filed a civil suit, they have got a degree. Thereafter, they have.
Why he will give me check?
They have the check episode is finished.
No,
I have paid the entire amount.
There is presumption that you have
No
taken
presumption. No, don't argue like this. Give me the time, then in your turn you reply. So it is a case. Total episode was a concealed. Civil court proceeding was there simultaneously. If somebody supplies the material, that comes under the clearly for non-payment, if any, comes under the parlance of the civil jurisdiction. They have invoked and vexed me in the two litigations. One, I have cleared up the litigation. Second one, my lords kindly come to the third page of the impugned order. On the third page of the impugned order. May I read at the very last paragraph? I will. Then certainly the offence under 406 and 420, it appears to have been made out against him. Admittedly, PW1 filed under section 138 of the NI Act against the accused or by suppression of such material fact. Present case was also filed against the same accused. Admittedly, no question of limitation arose in respect of 3759. This is another case, 138 case. This is the case number of 3759. It is this self-same cause of action. This case was also filed, concealed. Then court observed the courts of our country are overburdened so and so in the cases. In such circumstances, if series of the cases are allowed to institute especially cases of like nature, or the corporate sector will be the first to take the advantage of this. Will file courts of the cases under section 2420 IPC along with their money recovery cases under 138 NI Act to make this system a standstill. This is nothing but a luxurious case to take part in an unequal fight, to give lessons to the accused out of the professional. Then I cannot read because some was more, so that the say to understand how the accused number 2 has been. Then court came to a strange position that how the accused number 2 has been incorporated in this case along with the accused number 1. Accused number 1 has now a dead person, where no iota of evidence in present.
The evidence you have relied upon.
Yes.
You have not proved the case.
He has not failed to prove the case.
He's reading here and there.
No, he's reading here.
Please, Mr. Saru, I have gone through the total judgment. You have not, your expert report has not been exhibited, nor you have proved. Correct.
The evidence was not properly observed by the learned trial court. Have annexed the evidence also.
That is the case because
the evidence is there.
Your case they have denied with regard to the signature.
Yes, everything.
They have denied the signature. You have sent the matter to the expert.
Yes,
Expert report has come. If the expert
False
report has
case.
come, it has not been proved.
Why person will issue
False case.
Maybe that. See, mere using on the check, then the 130 is there. Presumption cannot be in the 406.
120 conspiracy is there.
Presumption cannot be under 406. Presumption is under the 138. It can be.
Whatever evidence I have brought on record.
And if you have filed the complaint case along with the 138 application, you have not mentioned the 138 procedure.
Totally separate that I have read to your lordship.
That but you should be in clean hand. You filed a complaint case. You filed the 138 case. In the complaint case, you are not mentioned with regard to the issuance of the check. It has come an evidence only after the cross-examination, and why the cross-examination is given by the statutory.
Your lordship is well aware that complaint is not encyclopedia. Something comes from the evidence.
Not evidence by way of cross-examination, not by the chief, sir. Please keep it in mind.
Before pronouncing judgment, it was come to the court that these things are there. That has to be considered. Whether these factors were supporting my case.
Yes.
Then, my lord, in the next paragraph,
you show me which document you have proved the case. Which document you have relied upon?
Evidence your lordship is finding at page number 28 onwards.
Have that signature is proved?
My lord, just I.
They have been proved by giving the check. Delivery of goods, challan CS side, kindly see.
That's why that challan, where is the evidence that challan they have admitted? Show me the evidence.
But the signature is there, that was.
That's a signature. That's a signature. Whether they have admitted, yes, this is my signature.
But where?
And you have sent to the expert report. Expert report has come.
Search for an accused who will admit in criminal court that see, I have signed this paper. This is totally an awkward situation. Yeah.
Not awkward. Yes.
In court that I have signed this paper.
In the Evidence Act, for the procedure for prove the case, two types of the proof. Either admission or by evidence. If admission need not to be proved.
I will make my detailed submission.
If admission need not to be proved. If you want to prove, then evidence is to be brought. For the evidence, either the person has to brought on record, put the question. If it denied, you have sent the matter. Please, you have sent the matter to the expert report. Expert report has come, but the expert has not been examined. Without the examination of the expert, whether the expert report can be taken into consideration.
Well, I answer to that. Well, I answer to that. Well, last but one paragraph of the judgment of the trial court. Last,
I gone through.
it is veracity has been doubted about the veracity.
Let the confident
Well, I have been suffered because of the false litigation.
The counsel for the party, the matter has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 19th.
19th.
Come ready with that.
Grateful.
Original side.
Huh? Yes.
This one matter which is quite 5th of September has not been listed till date, Your
5th of September.
I'm grateful.
I can.
This is not a company matter.
That was when my lord was complete. The matter was heard, but I mentioned the matter personally because there was some submission which did not make. My lord has been pleased to direct me to the matter, so the matter can be placed before project for hearing, Your Lordship. So this is the matter, Your Lordship. So I have indicated my other side.
Which matter?
Your Lordship, there is a direction that the court,
Acha, where is the Mr. Singh is there? I think so. Who is there? Who is for the petitioner?
I'm appearing for the applicant, manner. My simplicity case was that some amount was lying with the OL, and now, my lord, your lordship on the last occasion had directed the OL to disburse the amount. Now, my learned friend on that day itself had mentioned the matter before your lordship that I think.
There was some communication.
But on the
Go the regular court. Now this court will not pass any order.
If it's not parted or something.
With regard to
Yeah, seniority. Who is the senior?
May I have your lordships kindly to mention item number 6, my learned friend is there, the extension of interim.
But I have one prayer, Lord. Extension of interim, that deed, Lord, that deed which was executed according to them after the injunction. But I would only make one request. Lordship may extend the interim order. I can't join issue there. The matters are being fixed every Friday. Now, Lordship knows every Friday there is a mandatorily there is a 3:30.
No, every day from 3:30 onwards. Every day.
If your lordship could keep this.
One day my own original of
Well,
the
yes.
and the other day the original side.
Every alternate day this matter if it could be kept. I'm grateful.
Recorded.
So, Manoj, this matter would remain in the list, Manoj, and it would come on Tuesday or
Matters will be remain in the list. Now your matter will come on Tuesday, Monday.
Monday. I'm so grateful. Grateful.
At the top.
Well, yes.
Original
Original side. Ordinary original side.
But my learned friend is getting so jubilant, but he doesn't know your lordship has fixed an entire evidence from 3:15 to 4:30 on 3 days.
Then, Malad, on Wednesday.
Also Wednesday.
Let us see.
No, Malad, let it be in the list. Malad, we will
Concept for the petitioner. Place for extension of the interim order.
Mongolbar
According interim order is extended.
Then Brihespatibar
Extended till 27th November 2025 or until further order, whichever is.
My lord, I have a similar prayer in item number 64, my lord. The interim order is expiring today. And it was last extended on 5th of September, my lord.
64?
On, my lord, 64, my lord.
Who is for the other side?
My lord, I have given notice, my lord. Mr. Kakrani has appeared.
Interim order is extended. Then 27. number 2025 or until further order, whichever is earlier.
I'm so grateful, my lord.
That's kindly to mention item number 7 of your lordship's original side list, your lordship. Mr. Mitra, my lord, had mentioned the matter, my lord. I'm only seeking, my lord, let it retain its position in the list.
It will remain its position.
My lord,
I'm
may,
deeply obliged.
my lord, may I be permitted to mention one commercial suit, my lord. The matter was heard at length, my lord, and my lord had made this matter part heard, my lord.
Part heard?
Yes, my lord. Made
May I permitted to mention your lordship on code application for inclusion in the list, your lordship.
Which application?
Code application.
Lordship, may I be permitted? Lordship, this is for extension of interim order. My interim order is expiring.
Item number?
84.
Interim order is still today?
Yes.
Same.
This is the
Interim
last
order is extended till 27 November or until further order, whichever is earlier. ये क्या report है?
My problem.
कौन है? We appear?
I'm for the defendant.
You are appearing?
I'm for the defendant, your lordship. In the same matter, lordship. Same matter, lordship. Much over.
27th November. No police report is received. कौन सा matter? Report received, be kept with the record. Receipt filed by the so and so, be kept with the record. A receive of a report received from the Deputy Sheriff of Calcutta, be kept with the record. Let the matter remain in the list. Okay.